My lord,
Yes.
under the accompanying circumstances, my lord, I know your lordship's view. But my lord, I will take 2 minutes time, my lord, to dispose of this matter. My lord, I will make a comprehensive representation. My lord, kindly let it appear in the my lord, as mentioned matter, my lord.
It's appearing in the supplement.
Supplementary, my lord. Kindly, my lord. I will never trouble your lordship, my lord. I don't want 190, my lord. I will next day, any day, my lord. Next week, I will sub notice.
Now, my lord, may I have lordship's kind leave to mention a matter? Now, my lord, I earlier, my lord, mentioned the matter, and considering the urgency, lordship fixed the matter also for hearing. Now, my lord, what happened? State respondents came and took time. My lord, urgency is that, my lord, all the petitioner are senior citizens. Their land has been taken for last 40 years. State government admits that I am supposed to get 7.5 crore. My lord, this is the
The
situation.
motion stage.
No, my lord, it's in the hearing matter.
Affidavits are complete.
Yes, everything is completed, my lord.
Give the number.
Any day, my lord.
Give the number.
Your Honor, with regard to item number,
Let it appear.
with regard to item number, my lord, 735 and 736, similar matter, my lord. My lord, urgency is this, my lord. Petitioner is praying for land loser certificate. My lord, being the family member of the land loser family, but they are the, my lord, the primary recruitment candidate of the next primary recruitment that is going on. Unless the certificate is being issued by the land acquisition collector, they will not get any chance.
Give the number.
Your Honor,
My lord,
Your Honor, may I be permitted?
Just yet to be
hearing matter.
hearing matter, my lord.
Give the number. Let me see. It's
My
a
lord,
monthly list.
monthly.
My lord, may I permitted to mention, my lord, for upgradation motion, both are similar types. One is fishing tender has been given and another one is mineral tender has been given, but it is not extended. And they have given the representation, but not considered.
The monthly list.
Yes, my
Give
lord.
the number.
My lord, may I be permitted to mention, my lord, one matter which was heard on 7th July 2023. Your lordship directed that the matter will be heard on 27 July 2023. But my lord, by mistake,
Which will it?
I write on the brief that the matter will be heard on 17th August 2023. But the matter was heard on 27 July 2023.
Which item number?
Item number was 57. Already disposed of. And from 17th August to 4th September, I searched very much, but nowhere. Then I rang to the petitioner lawyer. Then he told me that the matter was disposed of. But if my name is not listed, I could not prepare the bill, my lord.
Your Honor, may I be,
Milord, may I be permitted to,
Give the number, please.
Milord, may I be permitted to pray your lordship's leave to move an urgent motion. Milord, urgency is this: tomorrow 12:30, the respondent will demolish my dwelling house, Milord. Order was passed on 14th August. I have preferred an appeal, Milord, because the district magistrate appeal is pending, Milord. During pendency of the appeal, the respondent will come and demolish my dwelling house, Milord. My appeal will be infructuous, Milord.
Where is the order for demolition?
Milord, police inform, Milord, they will come.
Show me the order.
Milord, this is the order, Milord, passed to under
Order
section.
demolition that you are saying tomorrow it will be demolished. Where is that order?
No, Milord, no such notice has been served. Police came and informed me verbally, Milord. Order passed by the subdivisional magistrate under section 10(3), Milord,
Yes.
directing to demolish within 1 month. Milord, in spite of that, yesterday, Milord, police came and informed me that tomorrow 12:30 they will demolish.
I'll give the number. I'll keep it tomorrow.
My lord,
Number to dinner, কালকে সাড়ে দশটায়। Copy করো। Please, sir,
But unless your lordship grant me leave, the office of the
there is no document to show that tomorrow there is a
office
demolition.
of the government pleader will not accept the notice, Milord.
That tomorrow
But
there
I
is
have
a
categorically stated, Milord, police came and told me, Milord,
requested to demolish by tomorrow, but there is no threat of demolition.
Milord,
Fine, come back, give the number, other I'll not grant leave in this.
my lord, may I be permitted on matter, my lord, for inclusion in the daily
I'll
list from
take
the,
number to record, I'll fix it immediately and put the other side on notice.
my lord, for inclusion in the daily list from the monthly list, that is item number 999, my lord. My lord, the matter is last 3 occasions, your lordships has on mentioning, your lordships has granted the from daily monthly list to daily list. My lord, this is an Petition against an unauthorized construction, my lord.
Give the number, please.
My lord, may I be permitted to mention one matter, my lord? It is a contempt application, my lord. The order was passed by your lordship on November 17th.
For the first
Yes,
time.
my lord.
Give the number.
May I have your lordship's kindly,
Give the number, please.
may I have your lordship's kindly to mention, my lord,
Grateful, my-
item 604 of the monthly list, my lord. What has happened, my lord, my name was assigned by the RR department regarding the land, my lord. The RR department is not executing the deed. I am praying for only expeditious dispatch.
Give the number, please.
Your lordship, kindly to mention, my lord, the urgency is that, my lord, this matter was appeared on 29th. And I mentioned this matter on that day, my lord, my vehicle will be confiscated if it is not, my lord, this taken up by tomorrow. My lord, this matter is tomorrow, my lord, this matter is appearing today under heading, my lord, item number 270 of today's list. My lord, if it is not taken up today, my lord, this will, it is tomorrow, my lord, that's only. I mentioned this matter earlier, your lordship.
My lord, may I be
Motion, group 7 motion.
Upgradation, my lord.
7 motion, কালকে একটু উপরের দিকে রাখো।
For upgradation, my lord, my land has been acquired, my lord, and transferred to third person, my lord.
It is in the monthly
It
list.
is monthly list, my lord, 193,
Give the number, please.
my lord.
My lord, may I be permitted to mention the matter? The petition is a Sonirbhor Dol organized by the fishermen under the name and style Baidyanath Motsyo Chashi Sonirbhor Dol and favor the lease of a water body named Korondigi Pond, Gangarampur. The agriculture mechanical department have been lifting water from the said pond, supplying the said water to the adjacent farmers. As a result, depth of the water rapidly decreasing, day-to-day insufficient water, fish products are going to be destroyed. And this is the
It
pictures.
is in the monthly list.
Today list 128,
Today's list, it will be considered. You don't have to mention.
today's list.
And consider.
May I permit to mention item number 1005, madam, for month. The land has been acquired, I mean, including the structure of the. But the land has been acquired since ago, but still now no compensation has been. We have filed the, from RTI, we have had the information that the land has been acquired.
It's in the monthly list.
Yes.
Give the number.
Lordship, may I be permitted to refer and lead lordship in these matters to one rubber stamp of additional district judge first court Jalpaiguri and one rubber stamp of interpreting officer Calcutta High Court original site has been used to declare to confiscate the land by the statutory authority. I am praying for an urgent leave for
Determination.
lordship. Yes, it is a land matter.
You are alleging forgery.
No, for regarding the forging part, matter is already sub judice before his lordship Honorable Justice Joy Gupta, and matter has already been parted yesterday. Matter has been assigned for reply and etc. But my question is, my land has been already taken over by the authority concerned. In the meantime, considering that document.
Come back, give the number, I'll consider.
Yes, lordship.
Leave is not necessary.
As your lordship may fit it.
May I be permitted to mention one matter, urgent? Lord, when the matter was called on for the first time, the state had prayed for time. It was made returnable on 28th of August, but till then the matter could not be taken up and it is sliding down the list. The urgency is that the petitioner's land, he is in possession of the land, but his ingress and egress has been obstructed by the state authorities who have already failed to evict him. They had to come up before this court and withdraw the notice with the leave of the court to initiate proceedings afresh. They did not do that. Now they are illegally not allowing me to enter the property. I was being laid by Mr. Shaktinath Mukherjee.
It's appearing in the monthly list.
Daily list today as item number 99. Well, there is grave urgency. I cannot.
Can be called up, called, please wait. Daily list matters need not be mentioned. Yes, call the days list, please.
Item 1.
So I have for the writ petitioner, my lord, challenging the termination. Yes, I have put them on notice.
This is the notice. Yesterday.
So she was pleased to grant me protection from liquidation of the security deposit till yesterday, my lord, 4th of September. So I have mentioned this matter yesterday with notice to other side.
Lord, I am appearing for the railways, led by Mr. Tiraj Trivedi.
You are appearing? Yes. It's for extension of interim order today.
Yes, but
Yes.
lordship, report was called on and they have served the report to me yesterday.
Lord, I am submitting the report in the form of affidavit.
pursuant with your lordship direction dated 21st July.
Yes, you have served a copy?
Yes.
Yesterday, my lord.
You want to?
I want to
an
2 weeks
extension?
time, my lord. It's an outstation client. 2 weeks time may be given to give reply.
Let there be a limited extension?
Yes.
Yes. My lord, it may be detrimental for the railways.
Yes.
It may be detrimental for the railways if the interim order is extended.
No.
I do not follow.
He is saying, my lord, if the interim order is extended,
It
It
may
will
be
be
detrimental
detrimental
for
for
the
the
railways at this moment.
But there is
And a
already
huge
a
amount.
order. If it's not extended, the writ petition becomes
Yes.
infructuous. Will that not be detrimental to the petitioner? We have to strike a balance.
Yes, my lord.
so she fixes any date subject to lordship's
Report in the
convenience.
form of affidavit submitted on behalf of the railways is taken on record.
Sleep.
Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the heading group 7 motion on
Sleep nahi hai lekin, sleep ta din-
25th September.
Yes.
Paragraph, the interim order granted earlier is extended till 30th September or until further orders,
Great.
whichever is.
Deeply obliged.
I think so.
I'm for the petitioner, my lord. But here, a petitioner's land has been acquired. His maternal uncle's land has been acquired by the PW for the purpose of widening the road. Now my land, I have some shop rooms in the side part of land, the side of the road. Road has been enhanced, widened, PW is over. Now what happened? The one private respondent, Jyotish Chandra Relation 11, he is residing behind my residence, his maternal uncle's. Now he wants to evict me from that portion of land of my maternal uncle, where my business has been running for the last 50 years, not since 1970. Now the land has been acquired for the purpose of widening the road has been given. Now seems that Jyotish Chandra Mondol, using the state machinery, that path of land which is left behind, that has been given to lease to a private person, individual, in the garb of public purpose. Whether that is permissible under the law.
Can this court deal with it?
But my lord, also, can
This court deal with it?
yes, my lord,
It's a transfer.
it's a question of law. Public purpose has been defined in the number of judgments of the Supreme Court and the starting from Privy Council 19. I can show to your lordship.
My lord, I am big to appear for the private respondent, my lord. There are, my lord, suppression of material facts in this matter. My lord, 2 orders has been suppressed before your lordship, my lord. This is, my lord, the proceeding, my lord, under section 2 of State Highways Act, my lord. The court, my lord, first, my lord, this matter came, my lord, on 26th of March 2012 before Honorable Justice Soumitra Pal. This order has been suppressed, my lord. Your lordship can seize this order, my lord. There, my lord, the direction was given, my lord, that the state will make inquiry, and thereafter, my lord, if there is an illegal encroachment, the state, my lord, will, my lord, takes proceeding under section 10(2) of this act, my lord, and thereafter evict them, my lord. This is the order, my lord. Kindly see, my lord. First order.
So what has happened after that?
Thereafter, my lord, they came and challenged it before this Honorable High Court. This petitioner, my lord, came and challenged before this High Court. That order, your lordship will find at page 78 to 81 before Honorable Justice Dipankar Datta, my lord. Honorable Dipankar Datta, my lord, state, my lord, that, my lord, before proceeding with this, my lord, first this person should be heard. Thereafter, the proceeding should be continued, my lord. So, my lord, accordingly, my lord, they were heard also. They were heard. Thereafter, my lord, they came and challenged it before this Honorable High Court. Again, my lord, another writ petition, my lord, which is, my lord, WP number 35576 of 2013, which is also suppressed, my lord, not placed before this court, my lord. Kindly see, my lord, this order. Here, my lord, every point, my lord, which they are taking now, my lord, have been considered, and my lord, his lordship, Honorable Justice Joymallo Bakshi was of the view, my lord, that the proceedings should be concluded, and they will not get any relief. Kindly go through that order, my lord. These are all suppression, my lord.
Yes, how do you respond to this, sir?
Thereafter, my lord, this is not finished, my lord. Thereafter, my lord, the state was not taking action, my lord. So, my lord, again, we challenge it before this Honorable High Court, my lord, where they were present also, my lord. My lord, that order your lordship will find at page 83 of this petition, my lord. This matter came up before the Honorable Justice Joy Sengupta, my lord, on 9th of November 2022. Here, my lord, kindly go through this order also, my lord. This is also very important.
Page
Here, page 83, my lord,
of this.
of writ petition, current writ petition.
That is their writ petition, not mine.
Yes, they were the private respondent. They have been heard.
That is their writ petition.
No, my lord, kindly take their writ petition, my lord, which was filed before your lordship now, my lord, at page 83, my lord.
Their writ petition.
Page 83.
Send the matter to
Para 9. So, kindly go through this order also, my lord. This is also very important, my lord. Round of application, my lord. This is the 5th round, my lord, which is coming before this Honorable High Court.
Yes, there was a direction to conclude the proceeding.
Yes, my lord. Yes, my lord. This is the verbal option.
So I have challenged
But
the
that proceeding, my lord, this order, my lord, still remain, my lord. They have not challenged this order.
Yeah, I have challenged
It
this
is there, my lord. Now, my lord, previously also, my lord, with the same cause of action, they came before Honorable Justice Joymala Bakshi. It was rejected, my lord. Now, my lord, how many times did this person will come before this court, my lord? They are hit by res judicata 1, my lord. Second, my lord, this order stand in the face
So
of face, my lord.
what was the stake?
This order in contempt.
My lord, no. This order has been complied with, that the authorities are complying with, my lord. They are coming and challenging that portion.
What order?
Now, but if this order stay, my lord, and if this order is not set aside by an appeal, my lord, how can, my lord, the proceeding can be stayed, my lord?
What
This is
proceeding?
my proceeding.
Well,
Yes. After the DM's order, also several writ petitions are there before this court.
And why will they suppress all this?
What about the earlier writ petition where Justice Bakshi has passed an order?
WP number 3356 W of
See, but it
2013.
is-
How many time will he get agreed
I'm
by the
sorry,
order
sir,
of the
there is
DM,
no
my lord?
writ petition. This point has been agitated several times. The court has dealt with it. I'm sorry.
What is the prayer? They are prayer over.
entering the room or the house.
Same thing has been considered by my lord by 4 judges, my lord. Now your lordship is the 5th judge, my lord.
The matter has been decided. The entire matter is decided already.
But record has also been changed, my lord.
Fresh order.
The government has recorded the property to his in own name, my lord. That was the reason, my lord, they could not take step up before.
What is it?
What is the 22nd March order and the 19th April order?
22nd March,
Uh,
20
Prayer B and prayer C of the present petition.
Is there produced?
the nature was commanding respondent night to take since implementation ordered 22nd March 2023. 22nd March 2023. Just give me a moment, please.
Where are these two orders that the petitioner has assembled?
This order passed, my lord, in compliance with the Joy Sengupta's order, my lord. Honorable Justice Joy Sengupta's order, my lord, in compliance with that, my lord. Now,
Which order?
but 22nd March
Where
2020.
where is the order?
Yes, my lord. Just give me 22nd March 2020. ওটা কোথায়? So March 2020. এখানে
February.
that is strong, man. I think it would be 22nd February sort of.
Page 157, 158.
Or page 157,
22nd
150.
February.
Yes,
That's the
Divisional
submission
magistrate
magistrate's order.
my,
The 10-3 order.
yes, 10th order.
That has been dealt with in the earlier petition.
Yes, my lord. And this their objection has been dealt with by the other Honorable Justice Joy Sengupta also, my lord. Kindly see, my lord, in that order it's recorded that they have said that their right has not been decided and all. After considering that, my lord, this order has passed. And he has not make any application, my lord, for appeal while over there, my lord. That order still stands.
We have already decided. Challenge করলেই হয়।
What was the prayer? Can the accusation pay?
But acquisition has been made by in 1956, my lord. Now, my lord, 2023, my lord, he is coming and challenging that.
Cannot be. Public purpose. Road is public purpose.
Roadside land also, yeah.
I have been there for plus 50 years.
I'm sorry, sir, you have no case at all. Yes. Anything to add, Mr. Bear? Not necessary at all. The petitioner is asking for evidence unknown to law.
That is why
Yes.
regarding the matter.
Sir, you have made a lot of efforts for your client. I don't think anything further is required. Do you want to make any further submission?
Why they have made suppression, my lord, first let them
All
say
that
say
is
that, my
decided,
lord.
sir, in all these earlier.
Two orders have been
petitions,
suppressed.
Decided. Yes,
After 42 years, I have been there. I have.
sir, all these have been decided in the earlier petitions. Do you have any further case to make out?
Totally decided.
It is decided, sir.
Well,
As
then
far
they
as
could have
my
filed an
legal
appeal, my lord, that
conditions-
this has not been decided, my lord. Then that was the ground for their appeal, my lord.
I already filed a pending.
I
Where
देखो,
is- where is
that is
that?
also not made over here, my lord. That is also been suppressed.
That is also suppressed. You have not stated in your writ petition.
My parallelly, my lord, writ petition also, my the appeal also, my lord.
Before that.
কোথায় হাইকোর্ট appeal ফাইল করছে কোথায় বলেন তো?
Third learned counsels for the parties. So. Petitioners have assailed the order passed by the subdivisional executive magistrate on 22nd February 2023, though the same has been wrongly recorded in prayer B of the writ petition as 22nd March 2023 and March 2023, February, March, and also the order passed by the district magistrate on 19th April 2023. Stop. The petitioners claim to be in possession of the plot in question for considerable period of time and submit that the shops run by them therein do not encroach upon the PWD road in any manner, and even after completion of widening of the road, 4 feet vacant land is lying between the road and the shop rooms of the petitioners. Stop. The petitioners allege that the private respondent who has his land on the land behind the petitioner's SL4 land has falsely alleged that the petitioners are causing obstruction in his egress and ingress only with a view to harass the petitioners and obstruct them from carrying on their lawful business in their land. Yes. Paragraph 17, 17. Is there any stay? It doesn't stop this court from passing an order. Doesn't stop this court from passing an order.
He could have pursued that appeal, my lord, that was his relief, my lord, not this writ petition, my lord. No stay, my lord, there is no impediment, my lord, in passing now.
Why you moving?
বললাম না। Proceeding under section 10 of the West Bengal Highways Act 1964 was initiated against the petitioners, and an order passed under section 10(3) of the Act. The petitioner referred an appeal against the said order under section 10(4) of the Act, which was dismissed. Stop. Both the orders are assailed in the writ petition. Paragraph. Learned counsel for the private respondents takes this court to three writ petitions filed earlier.
My lord,
Three
yes,
writ
yes, my lord.
petitions.
But
Three
I shall give you
petitions.
lordship the WP number, my lord. First, my lord, so Honorable Justice Soumitra Pal, my lord, dated order date is 26 March 2012.
That was by you.
That is by us, my lord.
Yes.
That is by us,
Three
my
writ
lord.
petitions
Thereafter, my lord, Honorable Justice Dipankar Datta's order.
filed before coordinate benches of this court
One, the Joyce,
earlier. Stop.
Joy Mollabakita ki
The
file
first
করেছে আমরা
petition being WP 4425 within bracket W of 2012, filed by the private respondent herein, was allowed by an order passed on 26th March 2012.
Thereafter challenging that, my lord, they came before Honorable Justice Dipankar Datta, my lord. That is at page 78. Page 78 to 81.
Directing the state respondents to hand over peaceful vacant possession of the plot in question in favor of this private respondent within a stipulated time frame. Stop. The present petitioners filed a writ petition being WP number 35576 within bracket W of 2013, challenging the action initiated by the state authorities against them for removal of encroachment on public highway. Stop. The issues raised by the writ petitioners in the present writ petition were also raised in the earlier writ petition and considered by this court in the order passed on 29th January 2014, by which this court turned down the prayer of the petitioners on an observation that it was open to the statutory authorities to deal with the public land in accordance with law, and the petitioners could not have any legal right to object to the same. Stop. Since the state authorities did not take appropriate steps against the present petitioners in terms of the earlier order, comma, the private respondent approached this court in a writ petition being WPA 23138 of 2019. Stop.
2015.
My lord,
By
it
an
was
order-
2015, my lord.
2015, 23138 of 2015. 2015. Stop. By an order passed on 9th November 2022, comma, this court comma, upon consideration of the submission made by both the parties, comma, directed who was the ninth respondent therein?
Ninth respondent.
Subdivisional officer.
The subdivisional officer. Directed the subdivisional officer to conclude the proceeding under section 10 of the Act of 1964 at the earliest, comma, positively within 2 months from the date of communication of the order, after hearing the concerned parties, including after hearing the concerned parties. Stop. The order under section 10(3) was passed in compliance with the order of this court, and appeal under section 10(4) was dismissed upon hearing the parties. Paragraph. The petitioners have suppressed material facts before this court insofar as the writ petitions being WP number 35576 within bracket W of 2013 and WP 4425 within bracket W of 2012, এটা 12 টা আগে দেবেন, 13 টা পরে দেবেন। Were filed. Stop. All the issues raised in the present writ petition by the petitioners have been elaborately dealt with by coordinate benches of this court in the earlier writ petitions, wherein the courts directed initiation as well as conclusion of proceedings under section 10 of the Act within a stipulated time frame. Stop. Paragraph, it is submitted on behalf of the respondents that the authorities are unable to take necessary steps in compliance with the court's order due to continuous resistance raised by the petitioners in and out of court. Paragraph. Upon consideration of the submission made on behalf of the parties as well as material on record, comma, this court is left with no doubt as to the fact that the issues raised by the petitioners have already been decided by the earlier benches it decided in the earlier repetitions, and no further case has been made out by the petitioner in the present petition, which warrants a favorable order. Stop. Paragraph. In view of the above, it is held that the writ petition is devoid of any merit and is liable to be dismissed. Paragraph. Accordingly, the writ petition being WA such and such is dismissed. Paragraph. Who should execute the order?
Subdivision already PWD of the
The executive engineer. Maybe
It has been
That-
corrected, my lord. They have submitted before
Because
the
I-
Honorable High Court.
possession, you're in illegal, unlawful possession. You're in unlawful possession, you have made the portrait in your name, no difficulty. The executive engineer, sixth respondent,
Executive
Right.
engineer, time on public.
the fifth respondent is directed to take necessary steps for removal of encroachment made by the petitioners on public highway, on public land within 1 month. I'll record that. Within 4 weeks from the date of communication of this order. Paragraph, the fifth respondent is the eighth respondent
Superintendent of.
is directed to render all possible assistance.
That's no, superintendent.
Superintendent of police. The eighth respondent is directed to render all possible assistance to
Sufficient.
the fifth respondent in executing the order passed by the district magistrate under section 10(4) of the Act of 1964. Paragraph, there shall however be no order as to costs, since no affidavits, urgent certified.
If you oblige.
Sorry, sir, can't help. You can take back the documents.
Yes. But will we supply your lordship an order, a copy of this order, but as your lordship has relied upon, but we will supply a copy.
It can be on record.
Yes, sir.
Because I've relied upon these judgments.
Yes. This year you can.
Next.
Item 3.
In this matter, Mr. Pintu Karar is appearing for the petitioner. Kindly make it not to the my lord. He is not present.
আপনাদের কোনো ক্যান ফাইল হয়েছে ক্যান 1
আমার ম্যাটার না আমার ফোন করে ইনস্ট্রাকশন দিলে নট
ক্যান 1 ফাইল হয়েছে
আমার ম্যাটার না আমাকে ফোন করে বললো নট করার জন্য আমাকে
for extension interim order paragraph by consent of the parties. The writ petition is treated as on business and taken up as of business and taken up for consideration. Extension interim order. Yes, 3, you're not ready.
No, my lord. In this matter, Mr. Pintu Karar is appearing for the petitioner, my lord. He is not present, my lord. Kindly make it not to the my lord.
Can 1,
Due,
you are the petitioner.
no, my lord. Mr. Pintu Karar is appearing for the petitioner. Due to illness, he is not present, my lord. Kindly make it not to the man.
Who has filed the scan 2 of 2023? On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th September. Item 4.
This is that matter, my lord.
My lord knows, my lord kindly recall, my lord has granted me leave to file a prefer an appeal. And my lord, for which I have made a request to my lord so that my lord can pass an order directing me to withdraw the original certificate from here. But my lord, that direction was there, but not here, from here. So department, it was sent down to department. So unless, and it has not sent down to the SR. My lord knows that. So my lord, so my lord kindly SR, unless, because I have to collect it from SR, or my lord pass an order so that I can take it from the department.
My lord, on the last occasion, my lord directed them, since they're dragging the matter. Sir, একটু আমাকে বলতে দিন। Sir, since they're dragging the matter, my lord, it has been withdrawn twice, not once, twice. My lord directed on the last occasion to come with a compliance report.
My lord, kindly recall, my lord, that on the last occasion that it was there. But my lord, yesterday or day, but my lord, it has not sent down to the SR. SR, because from the SR I have to collect. File is in mandamus.
Apply করেছেন? Go back to the stamp reporter. Stamp reporter, no function here.
Stamp reporter, because I have to, because if I go there, because it has, unless I have to collect it from the SR, stamp reporter department, because this is the all review appeal, my lord knows that it has to be.
If you go down to the department.
And everything, I have complete everything. The appeal, stay, section 5, everything is ready, because I did not get that. Because my lord, yesterday, my lord, my clerk went there. But he tried his level best so that he can collect it from mandamus. But they are saying that you have to collect it from here. So that's why, my lord, I have requested, my lord, so that I can take it from here.
The alleged contender seeks to prefer an appeal against the order under contempt. Paragraph, on prayer of the alleged contender, liberty is granted to withdraw the to take back the certified copy of the order under contempt
প্রবীর বললো যে ওখানে গেছিল
from the file upon replacing a photocopy thereof. Please replace it by a photocopy, take back the original certified copy.
My lord,
To replace it by a photocopy.
yes, always, that is the system, my lord. It has to be enclosed.
Paragraph, the department is directed to do the needful.
Yes.
Paragraph, let the matter appear under the same heading on 25th September. If there is no stay, I will issue rule.
My
I
lord,
will not grant you any.
Grateful,
further
lordship. 25 September.
My lord, if my lord has given direction so that I can collect it.
And next day I will not hear all these. that
No,
you
my lord,
collect the
because
certificate.
if that direction, actually, I have sought for at that earlier point of time. That's obliged.
Grateful, lordship.
Now it is your choice whether it is a stay or.
No.
Yes, ma'am.
Obliged.
Item 5. Yes, who is appearing for the applicant? You are appearing? No one for the applicant. None appears for the applicant petitioner. Let the matter appear under the same heading on 28th September. 28.
Item 6.
Yes, my lord. So that you want. Or they,
So they,
that to got a content badge in content petitions, the respondent of that, the days upon respondent of 5. Well, if respondent 2 is the authority. That days upon in place of 5, that will be 2. Only that portion. And the other day, my lord, I took time, my lord.
And my lord.
Only 2. In place of respondent 2. Regularly yes, yes. So it's directed 5. The order I have, any my lord.
review টা এসছে? Review 192. Second review, একটা withdrawn হয়েছে তারপরে review.
192. Order. In paragraph of the review petition, I have already stated. In contempt petition, they have filed a report and stated 5 years not the authority that will be considered regarding payment of compensation is 2 in terms of our direct purchase policy.
Review has been filed by you.
Yes. I have filed because that is my headache. But since the respondent of 5 did not comply your losses order, we file an application for contempt. In the contempt, my lord, they filed a report. Though we send all communication to respondent number 2, and the respondent number 2 is the authority, the collector. And he will. Then your loss is also granted liberty.
So let this be done. Review 192 of 2023. The petitioners seek review of the order passed on
30th March 2023. 30th March, my lord.
30th March 2023.
Yes. No, it's a contempt petition. Original order not 30th March. Sorry. 7th October.
7th October
10th October,
2021.
Yes.
On 7th October. Yes. Without consent. Yes.
Hey, obvious.
In Apple court, my lord, I am facing difficulty.
No.
Passed on 7th October 2021. Directing the 5th respondent to deal with the matter and consider the proposal for direct purchase of the property in question from the petitioners in terms of the memorandum. Paragraph, learned counsel for the petitioners submits that in the affidavit of part compliance, that in the affidavit of part compliance, comma, the alleged contemner has stated, paragraph, this is part compliance, 16 December 2022. So there's another compliance. 1st February 2023. Paragraph. It has been sent to the district magistrate. But where is it stated that the district magistrate is the authority? Where does it say that the district magistrate is the authority? So I have to record your submission in that case, that he is the authority. I have to record the submission of the state in that case. কি বললেন? এটা কেটে দিন, এটা কেটে দিন, এটা কেটে দিন, হ্যাঁ। Learned counsel for the state respondents submits that the second respondent has the authority to comply with the order passed on 7th October 2021. Paragraph. The review application is allowed on that score. SURA. Paragraph. The order passed on 7th October 2021 be modified to the extent that be modified as follows. In inverted comma open করুন. The writ petition is disposed of with a direction upon respondent number 2 to deal with the matter and consider the proposal for direct purchase of the property in question from the petitioners in terms of the said memorandum. Stop, inverted comma closed. Paragraph. The remaining portion of the order shall remain unaltered. The review application being RVW 192 of 2023 is accordingly disposed of. There shall however be no order as to costs. Urgent certified website copy. Contempt order CPAN. I'll give you some time to comply. Yes.
If the particular pass the order of the.
You will decide that.
I have only substituted the second respondent in place of the fifth respondent. The remaining part of the order is as it is. So I'll give you some time for compliance.
Also be a party of that.
In addition to,
Yes. No.
in addition to the,
Money will be paid by the. Money will come from the finance department.
শেষের দিকটা যেটা ইনভার্টেড কমা করলাম না, ওখানে করুন রেসপন্ডেন্ট নাম্বার 2, the second respondent along with the fifth respondent. Along with the fifth respondent.
The fifth respondent is.
He is already the Jason up, him also there.
ওখানে second respondent has the authority বললাম, ওখানে second respondent and the fifth respondent has the authority. তার আগের লাইনে, তার আগের লাইনে।
Finance department. Finance department. Finance department. Not in this case. Otherwise, finance department will pass the order.
But let the district magistrate, the member of the purchase committee, but they will take a decision.
Department at the moment should not be required. Let the district magistrate play his part.
Yes.
After that, if required, I'll just pass, I'll add a line to the order. ও করলেন তো ওখানে করুন contempt application এ করুন in view of the order passed in RVW such and such. The district magistrate and land acquisition collector, 24 Parganas within bracket south is added as alleged contender number 2 in the contempt application. Paragraph, learned counsel for the alleged contemners seeks extension of time to comply with the order under contempt. Yes. Added যেখানে করলেন না, তারপরে করুন the petitioner is directed to petitioners are directed to serve copy of the contempt application along with annexure thereto upon the added contender number 2 and file affidavit of service on the urgent date. Paragraph, তার পরের লাইনটা কেটে দিন। Learned counsel. No. Paragraph, let the matter appear under the same heading on 26th September. 26th September. You need the name, yes. You cannot add the collector in a contempt application. The name is required. ওখানে contempt application টা বলুন তাহলে। Yes. That is exactly what the learned counsel is saying. Contempt এর জায়গাটা বলুন তাহলে। Contempt application টা পড়ুন একবার। এটা তা না করে করুন in view of the order passed on week, liberty is granted to the applicant petitioners to add the as alleged content number 2 in the contempt application. Paragraph, the cause title of the contempt application be amended accordingly. Proper service of notice. ঠিক আছে? Yes, you need to have the name. Review. 2 and 5, same.
কারেকশনটা কোন করবে তো নামটা কালেক্ট করো।
Item 8. Item 8. We are in item 8, sir. I cannot go back. Yes, order passed. So come back on the next date. You are appearing for the applicant petitioner and you do not have a copy of the contempt application. Department নামে দিতে ফাইলটা 5টা এখন অর্ডার করা যাবে 8 same order. Ashok, same order. Next. Item 10. Item 10. Yes. Review application. Have you received a copy? Section 5 to the review. There's a can 2 also. No. What is this can 2? Yes. Can 2 দেওয়া হয়েছে Huh? You don't want to use an opposition to this, Mr. Pan? You don't want to use an opposition to this. You like to? Rajana. Because it is the state's review application, so the state has to substantiate. And producing records on merits, I have my doubts. How far this court can reconsider? Review 212 of 2022 তে order করুন। Learned counsel for the petitioner seeks to use an affidavit in opposition to the application. Paragraph within 2 weeks. Affidavit in opposition be filed within 2 weeks from date. Paragraph affidavit in reply, comma, if any, comma, be filed within a week thereafter. You can annex all relevant documents to your affidavit. Paragraph of the matter appear under the same heading on fourth after So let the date be by consent, 23rd November. 4 weeks. Opposition to 4 weeks korun and reply within 1 week thereafter. 4 weeks or 1 week korun. Paragraph, let the matter appear under the same heading or? Yes. 4 weeks, 2 weeks korun. 23rd November.
পরে 23 নভেম্বর। হ্যাঁ।
In this matter, item number 12, I need to appear on the petition before your lordship.
Authority, Milord, I may hand over this and to also to him, our Milord. Milord, the problem, the predicament, Milord, 29th May 2023, Milord, the government of West Bengal, Milord, Department of Urban Development, Milord, Municipal Affairs, Milord, it has issued a notice which, Milord, says ultimately, in order to avoid, Milord, the fourth para from the top of the authorities for working similar types of developmental work, state government has decided to merge HIT with KMDA. Now, therefore, in exercise of powers conferred by subsection 1 of section 184 of the said Act means, Milord, West Bengal Town and Country Planning Act 1979, because it functions under, performs its function, Milord, under this Act. Now, therefore, in exercise of the provisions conferred by subsection 1 of section 184 of the said Act, the governor is pleased hereby to supersede the board of HIT called the Trustees for the Improvement of Howrah with a view to better coordination and speedier execution of development work and maintenance of Howrah city and its vicinity with immediate effect until further order. In consequence of this supersession, in terms of provisions of subsection 1 of section 184A of the said Act, the governor is also pleased to direct that next page, Milord, kindly I'm skipping over. Milord, 2E, all legal proceedings instituted by or against the board of HIT may be continued or enforced by or against the KMDA. Milord, from 29th May 2023, Milord, we lost all our authority, Milord. We merged it. So, Milord, KMDA, Milord,
Should be a necessary.
because it can sue and be sued.
This is my writ petition, Milord. May I, Milord, submit my, Milord, case before your lordship?
You heard
This was my lord.
Have you heard the submission made by Ms. Learned Counsel?
My lord, pardon, Milord,
Have you heard the submission made by Learned Counsel?
No, I can't, Milord. I can't hear. That is why, Milord, I am not submitting anything. My learned has started being respondent, Milord. I was keep quiet myself, Milord. What he has submitted, I could not hear, Milord. But my submission is before your lordship is this, Milord. More than 44 years back. And acquisition proceeding was started.
Madam, before you start, you're not able to hear us?
No,
We are not audible.
now I am hearing, Milord. Now I can hear.
Learned Counsel submits that the HIT has merged with the KMDA. So the HIT doesn't have the authority to deal with the writ petition now. The KMDA needs to be added as a party.
Milord, if it is at all needed, Milord, certainly, if it is at all needed.
The circular says so. Please hand
Milord, I don't have any copy to what is placed before your lordship. I am not.
Junior friend is having a copy. Since you are virtually appearing, you cannot have a copy at the moment. Your junior friend is having a copy. And in view of the circular, the KMDA is a necessary party now. The
If your
HIT
lordship,
cannot deal
previous
with the matter.
certainly, certainly, but my at all, Miller, what I am submitting, if your lordship,
And
this is
the
a
KMDA as a party serve them and come back.
This is a clear case of return of the property in question, whether the
That
land
is on
acquisition
merits,
proceeding
madam.
is
You are
still
on merits.
subsisting or
You
stood
must
there-
understand you are on merits. The HIT has merged with the KMDA and the KMDA is a necessary party now. The HIT is not in a position to deal with the matter. Yes, is it clear?
Your later copy is served upon my landed.
I have handed over first.
Served. It has been handed over.
As your lordship, then your lordship pass an order, necessary order.
By the government on before one hour, and most of the.
You are appearing for?
I'm from the state. I don't like Mr.
So let the KMDA come.
Most of the awardees, take their.
We'll hear it out on merits, sir. Let the KMDA join us. You've seen this circular. Have you served him a copy?
No, because he's a state, I thought, Miller, that she should be given first, but I am giving.
Let him go through it. Learned Counsel for the Howrah Improvement Trust. Draws the attention of the court to an order of the Principal Secretary to the Government of West Bengal, dated 29th May 2023, which demonstrates that inverted comma open quote, in exercise of powers conferred by subsection within bracket 1 of section 184 of the said act, a capital comma, the governor is pleased hereby to supersede the board of HIT capital comma called the trustees for the improvement of Howrah with a view to better coordination and speedier execution of development work and maintenance of Howrah city and its vicinity with immediate effect and until further order. Stop. Inverted comma closed. In terms thereof, comma, properties, comma, funds and dues vested in or realizable by the board of HIT has vested and is realizable by the KMDA. Stop. The order further indicates that all legal proceedings instituted by or against the board of HIT may be continued or enforced by or against the KMDA. Paragraph in view of the above, comma, liberty is granted to the petitioners to implead the, what should be the exact nomenclature? Chairman? Chairman KMDA. The chairman, comma, KMDA as respondent number exact designation টা নিয়ে নেবেন মিস্টার বাসুর কাছ থেকে, হ্যাঁ KMD এর এক্সাক্ট যে নমেনক্লেচারটা হবে সেটা ওনার থেকে নিয়ে নেবেন অর্ডারটা করার আগে। Respondent number 7 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, the petitioners are directed to serve copy of the writ petition along with annexure thereto upon the 7th respondent and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 3rd October. Please serve and come back. বাসু করার আগে নিয়ে দেবেন মিস্টার বাসু, দেবেন ওটা নিয়ে। Please switch on your microphone.
I'm led by Mr. Mukherjee.
Yes,
I have got any case, my lord, according to.
you are not ready?
My lord, I took some time, my lord, because my lord,
কবে করবে?
I am sorry. স্যার আমি আপনাকে একটু ডিস্টার্ব করলাম, এটা আমার পড়া হয়নি বলে পরের দিন করে দেবো।
Entirely up to honorable court. I have nothing
It's
to
not
do.
ready, Mr. Mukherjee, today.
পরের দিন স্যার করে দেবো।
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on. When will you come back?
My lord,
Mr. Dev, when can you come back?
last week, my lord.
28th September?
Yes, ma'am.
28th September, sir?
28th is a holiday.
28th.
Everybody
28th.
is after it.
28 holiday.
Muslim,
28th September is not a holiday.
no, it may be declared a holiday. Your lordship has got. Huh?
28. ও আচ্ছা আচ্ছা।
28 is 28 is a Muslim
Oh, so
festival.
let it be 27th in that case?
Yes, ma'am.
27th. It's not yet declared.
Not yet declared.
We are not aware, yes.
Uncertain movement of the moon.
Absolutely, yes.
Last moment.
Now we are conquering the moon. Chandrayaan 6 চলে
27.
গেছে।
Go and check there.
14.
স্যার স্যার
আমি আছি কি?
হ্যাঁ রিপোর্ট
হ্যাঁ, report হয়ে গেছে। My lord, on the
Yes.
previous occasion, my lord, I told that, yeah,
The
my
report
client has
is-
come, my lord, yes, ma'am, ready.
You received a copy?
No, my lord, just. My lord, now affirmation is a headache to us, my lord.
So it has been done finally?
Yes, my
affirmation?
lord. দাঁড়াও 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 না।
Maybe the report supports your case. No chance.
একটু দেন না।
Do you want to go through this and come back?
Yes, my lord. Yes, my lord.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on
তার মধ্যে 15 আছে।
27th September. 27th September.
16, my lord, same matter, similar. 16 similar matter, my lord, I filed the report.
10, 16, 15.
16 similar matter.
15?
15? আমার নোটিং এ ভুল আছে দেখো।
Same order.
Yes,
Granted.
হ্যাঁ সেম
16. Microphone.
ঠিক আছে শোনো।
My lord, Rameshwar Sinha is appearing behalf of the petitioner. His father-in-law passed away 2 days morning. My lord, I am praying for not this week.
This week হবে।
Who is appearing for the state?
We are appearing on behalf of the requiring authority, but the state I do not know who is appearing. But we had one request I submit to the kind sanction. No doubt your lordship last occasion directed us to file a report. Now, my lord, I failed to file the report. So may I get some extension of time? 3 weeks time may I get?
Who is appearing for the state? No one.
Because I do not know. Time Dana state ke আছে জিজ্ঞেস করছো?
ডিসিএল
তো কতটা বলতো?
petitioner. আপনি state কে serve করুন না, state ছাড়া তো হবে না। State এর আছে একটা কে, আছে দেখ, মনে নেই।
May I request Mr. Dey to appear in this matter? The state is not represented.
16.
Please serve a copy of the writ petition to Mr. Dey.
তুমি appear
Madam,
The petitioner, madam,
ম্যাডাম আপনাকে বলতে জজ সাহেব,
please serve a copy to Mr. Dey.
Yes, madam.
The writ petition copy. None appears for the state respondents. Mr. Dey appointment regularized current copy service direction. Paragraph learned counsel for the WBSEDCL seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, the petitioner also seeks accommodation. Paragraph, let the matter appear under the same heading on 4th October. 4th October. Please serve an advance copy to the petitioner. 10.
Lord, I am for the petitioner in this matter. I am happy on behalf of the respondent 2 and 3. State. Fine.
You are appearing for
Respondent 2 and 3.
state?
State. Your lordship directed to file exception to the petition. My report.
I need not to.
You did not?
Because I tell you, Lordship, why, my lord? Kindly have a look at that my case is this, my lord, that award was declared. I participated in a arbitration proceeding. Now, my lord, in terms of subsection 5 of section 31, a signed copy is required to be handed over to each party.
Yes.
That was not done.
Mr.
Because
Mondal for the state.
It was
where is he?
uploaded in the website. That's why,
My lord,
uploaded in the website.
that
Yes.
That's why,
upload does not help me to make an application under
Then
section
my lord,
34.
Sufficient service?
Yes.
I will.
You will. Where is Mr. Mondal?
He is,
He's engaged.
For the state.
he is
I am
also
led
for
by
the-
Mr. Ansam Mondal. I
Very-
am led by
very-
Mr. Ansam.
Now, my lord, they have in their report, my lord, they have made some law points. If your lordship kindly turn to, I don't know what is the relevancy of this one. Kindly have a look at the turn to, my lord, paragraph 9 of page 4.
Yes.
That it is further stated that the petitioner, after more than 3 years of willful acceptance of a arbitral award without any objection, and after receiving award payment notice from the respondent authorities, has approached this honorable court, thus within the meaning of section 23 and section 29A, as also amended provision of section 23(4) and section 20 with effect from August 29 of the Arbitral Council Act, does not warrant reconsideration of an order of arbitration after it had already been passed within the relevant period of limitation as per. I could not follow this.
What does this mean?
I don't know what does it mean. Let him satisfy.
No reconsideration is required. It has not been challenged. So what does these paragraphs mean?
It does not relate with the subsection 5 of section
Paragraph
31.
10 also
Yes.
talks about section 34. Why?
Well, it is, there was alternative remedy for petitioner to appeal.
Have
before-
you served copy of the award? Has the petitioner challenged the award?
No, no. That was not served, not that because.
Is the award under challenge?
No, I will
Challenge
some
can
kind
be
of short
section
direction, I will
34.
serve the copy of the award to the petitioner, my lord, and then
It is signed copy of the award, my lord, may be served.
And the other grievance was that party to the arbitral proceedings has served the payment notice.
Yes.
Can that be done?
And my lord, kindly have a look at the, my lord, that I will take the section 34 because your lordship cannot look into it. Otherwise, that is also bad. Without determining my quantum, my lord, I have been served with a notice. Our arbitration, my lord, act says otherwise.
But that I cannot take this thing for your lordship, my lord, I will take in the section 34. Let the signed copy may be served upon me.
It's allowed in terms of prayer A.
My lord,
Yes.
my lord,
please
my lord. Judgment is
Heard learned counsels for the parties. A learned counsel for the petitioner does not intend to paragraph to use an exception to the report in the form of affidavit submitted on behalf of the state respondents. Paragraph. Learned counsel for the state respondents candidly submits that a signed copy of the award, arbitral award, in connection with arbitration case number X1X/ARBI capital /2017, dated 18th August 2017, shall be made over to the petitioner within
2 weeks.
within 2 weeks from date. In view of the above, comma, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Paragraph. The same is accordingly disposed of in terms of prayer A, small a. Paragraph. Who should be directed?
My lord, the arbitrator,
Particular
my lord.
authority?
Arbitrator party name.
Arbitrator party not there.
Party name, party name.
No.
My lord, I understand, my lord, I understand, my lord, that the
Second respondent.
yes, competent authority who has issued the notice for payment of the arbitral award, he may be directed to hand over as signed copy.
Second respondent.
Second respondent.
The third respondent.
Third respondent.
Third
Yes.
The third respondent is directed to
No, no, second respondent. He is the arbitrator.
Second
He is the
district.
second respondent.
second.
Yes.
Is directed to
Competent.
a signed copy of the arbitral
Not
award
2 and 3, Jack.
to the petitioner within 2 weeks from date. Paragraph. There shall have been order first, no trespass, since no affidavit or urgent certificate.
And addition is
Obliged.
disposed of now.
Fixed at 12.
My lord, in this matter, I appear for the respondent number 8 to 30. On 27th July, my lord passed an order on that day. Intervener application was filed. My lord, that was allowed, lordship. And accordingly, as per order, we have served our copies upon the newly added party, lordship, that has been done.
Yes.
I appear for the added respondent. Added respondent. I have some point of objection on preliminary, not to say preliminary, that regarding maternity. I have some basic objection that
On merits,
Mal.
you'll have your chance. You'll
Mal,
get
mal.
your chance.
Okay.
My lord,
So it is that application,
I am for the petitioner, my
My
lord.
lord.
We have now.
my lord,
yes.
my lord,
Respondents?
yes, lordship. Mr. Rajiv Lal is appearing for defendant number 8 to 13. On the last occasion, he also appeared, lordship. He seriously has requested me accommodating because objection raised from our side, lordship. When the application was taken out by my learned friend, lordship. Thereafter, I came for modification order, lordship.
has requested me, Lordship.
And what about the SM authorities? You have come.
Yes.
Bad luck, sir. I believe learned counsel is seriously ill.
My affidavit is on record, my lord.
Yes,
I have made my
affidavits have
submission
been
also.
exchanged, Lordship.
I have made my submission also.
The added respondent needs to come with an affidavit.
Yes, my lord. My lord, I have received my learned friend's affidavit as well as the report from my learned friend, state government, representing the state government.
So do you want to come back with a separate affidavit?
If your lordship kindly give me permission.
The court will not direct.
No, my lord, I want.
The only thing I am requesting, my lord, let him file an advance copy so that, my lord,
Certainly.
Yes.
I come
Certainly.
all the way, my lord. At least hearing should take place, my lord. Well in advance. my lord.
এটা
Yes.
দাদার ইমেলটা নিয়ে নিচ্ছি
Yes. But since learned counsel has
অভিষেক
predicament,
আছে
please come back.
অভিষেক
Yes.
nor we should have.
The 14th respondent seeks to submit a report in the form of affidavit in this matter. Paragraph on prayer of respondent numbers 8 to 13. 8 to 13, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading. When can you come back, sir?
I have it sometime in first week of October.
First week of October? 5th October?
12th October will be.
12th October? Very good.
Lordship may kindly direct that the affidavit whosoever wants to file it exchange.
Yes.
Oh yeah, I'll do it.
Others have been exchanged, only the added respondent seeks to file.
Yes.
When in advance, that is the.
Jayanto, 12th October. Paragraph affidavit be submitted on the adjourned date upon service of advance copy to the others.
Fine, I'll do it.
To the other parties.
ঠিক আছে
So that we can deal with the matter on the next day.
Certainly.
12 o'clock is the time.
12th October, you said?
12 o'clock.
Very well. At 12 noon.
At 12 noon.
12th October at 12 noon.
My lord. I'm grateful to your lordship.
Respondents?
On the earlier occasion, several times they have been solved.
Ms. Sutradhar, Ms. Kia Sutradhar is appearing. Come on, at
On the
12.
earlier occasion, she is appearing.
Open record.
There is a private respondent also. Have you served?
Short Passover.
Passover is not possible in this court. I'm sorry. Have you served the private respondent? Toshinjit Ghosh. Where are the postal receipts? These are only the track reports. Oh, here.
Okay.
Where is the service on the first? I do not find the service on the private restaurant. Please find out. He's on Proceedings GHOSH. The postal receipt. During the course of the day, I should serve. How can you serve in course of the day? I'll give you some time, a short time, a date. Yes, I'll give you a short date, okay? None appears for the state respondents. Paragraph, since service upon the private respondent is not complete, comma, let the matter stand over till 26th September. Service upon private respondents is not complete. 26th September, please serve and come. And if you could intimate the state also,
About the state.
if you could, there was someone appearing, if you could just intimate. I found Mr. Bari's name and then several advocates' names are there. And service of the private respondent. 19. 20. 26. Switch on the microphone, you're not audible.
The advocate for the petitioner could not come to the court. Kindly not today.
Respondents? You're for the state? The petitioner is seeking adjournment. On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 3rd October.
This is as a delivery.
Service?
Yes.
Steps have been taken. They were SDO issued so-called notice to the private respondent. They refused to accept it. Yes, I'm for the state. They refused to accept it and they did not appear at the date of on the date of hearing. Thereafter, the SDO
Third time, my lord, your lordship will find third time, my lord. Ultimately, it was sent by the client from the Bahirampur, from where it appears when it has been delivered. If your lordship, my lord, can consider the subsequent and this one. I'll stitch it, my lord. I have handed over the copy, my lord. Initially, which I have sent, your lordship will find the track report. My lord will not find from there. Your lordship will find the last portion I handed over to your lordship.
Sufficient address.
First to inform same address. After that, my lord will find it was delivered to the addressee. Subsequently, it was returned with the investment insufficient address. I don't know how it can be done. Be as it may, my lord, subsequently the petitioner here in before lordship, the secretary, forwarded from the Behrampur post office, which has been soon to be delivered. He sent me the photocopy of the same. I'll take the responsibility by annexing by filing the supplementary petition. Your lordship wants. I've handed over to a copy, my lord, your lordship.
What is this HC address? HC
High Court. HC.
to HC address.
Yes, after that, my lord, it is fine. It is returned to the sender. If it is given to the addressee, there is no occasion on the part of the return to the sender. Be as it may, for the purpose of that, my lord, the next one I have photocopy of the same, my lord, your lordship find. From Behrampur post office, my lord, it has been delivered and it was held that your lordship find it was sent to the person who have received the same, along with the copy of the letter. My lord, got it? K. Ali, my lord, will find the person who received the Kausar Ali, the private respondent.
Kausar Ali and Fatima Bibi. SDO lordship, SDO also served notice, so-called notice to police. They refused to take it from the police, and then police posted the notice.
Who refused to take? Who refused? The private?
The private respondents.
They are practically.
They refused to take it from the police, and police then posted it in the wall.
Yes, that's why, my lord, unless until my lord. একটু জজ সাহেব একটু দেবেন ওটা আমি স্টিচ করে দিয়ে দেবো তাহলে
Lordship, this is my report.
Yes, what is the matter about?
This is, my lord, the removal of the encroachment from the government land.
The land of the Jila Parishad.
Steps taken?
Yes, my lord. The report says inquiry held,
Inquiry
steps taken, and
Showcause notice, Showcause notice was issued by the SDO, and they were also directed to appear before the SDO on certain date for hearing. They did not turn up and did not reply also the Showcause notice. And thereafter, the SDO passed an eviction order to vacate, directing them to vacate the land, encroached land, by 2nd September.
Let this be carried out.
Yes, logical conclusion, my lord. I am not.
Logical conclusion has been arrived at.
Arrived at now the logical conclusion regarding execution part.
This was pursuant to your representation that steps were taken. Or so.
After filing of the writ application.
After filing the writ application.
That your lordship find the order, though it is pursuant to the order passed with the Honorable High Court at Calcutta dated 27 to 2023. This is your lordship find 27th February 2023 order. There, though my lord was pleased to ask for the report like that, my lord, that was considered to be an order passed by your lordship. And then it is not pursuant to my representation or my application. After receiving the.
Okay, the purpose has been served.
Yes. They have initiated the proceedings, and after that, on basis of which they have.
Where is it says break out of the pursuant to an order of this.
Yes, my lord, here first order, 12th July 2023, the first page.
First order.
The middle, last part, one paragraph, bold letter. My lord will fine, but that is not the order like that.
Lordship verbally directed me to communicate the SDO to take steps. There is no written.
Yes, that's why, my lord, I cannot. So this was not.
I appeared in the matter. Lordship verbally directed me to communicate the SDO to take steps.
লেখা আছে তো পার্সেন্ট তো অর্ডার কাজ করেছে তো তুমি আমি টেকনিক্যাল জজ সাহেবের কাছে
Paragraph none appears for the private respondents despite service.
Yes.
The petitioner alleges encroachment of government land by the private respondents. Stop.
এবার ওষুধ বেঁধে নিয়ে চলে
During pendency of, it appears from the. These are the copies of the orders. Copies of. the
Yes,
orders.
copies of the orders.
Copies of the orders submitted on behalf of the state respondents that. During pendency of the writ petition, comma.
Yes. দিদি স্টিচ করে দিয়েছে
The subdivisional magistrate, comma, Berhampur, comma, Murshidabad
সদর মাইলর বহরমপুর
issued, yes,
বহরমপুর সদর মাইলর the existing was
the seal is Berhampur, no Shodar is
yes মাইলর I'm not
district,
subdivision
not subdivision. Issued notice upon the private respondents directing them to appear before him in person or through their authorized representatives on 28th July 2023. Stop. Despite service of the notice, comma, the private respondents failed and neglected to appear before the authority on the relevant date. Stop. By an order passed on 17th July 2023, 2nd August 2023, no. By an order passed on 2nd August 2023, comma. The subdivisional magistrate issued eviction order against the private respondents, directing them to vacate the public land and deliver possession thereof in favor of the Murshidabad Jilla Parishad, represented by the Secretary, comma, Murshidabad Jilla Parishad, within the next 30 days, comma, that is 2nd September 2023. Stop. The order further records that in case the encroachers do not vacate the public land within the stipulated date, comma, they will be, their eviction shall be taken up through issuance of an appropriate order in terms of section 5 within bracket 1 of the Act of 1962. Or the West Bengal eviction of unauthorized occupants. Act 1962. Stop. Second September is the date.
Yes. 2nd September fixed.
Paragraph, in view of the order passed by the subdivisional magistrate, comma, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. The subdivisional magistrate, comma, being
Respondent number 4.
the fourth respondent herein, comma, is directed to take necessary steps in terms of the said order. In accordance with law.
Some time frame of like that. I can visit your lordship, I can ask for the mandatory.
Within another month,
Another month, as per I have not.
within another month. Terms, in accordance with law, within, or should I add within 1 month. From 2nd September 2022.
My lord, I have stitched it and hand over to you.
Answer Madam, I'm appealing for the state
Next.
respondent in this matter. 21, I have filed my report. An exception to my report also has been filed.
Kindly not today. The learned advocate has some difficulty. He could not come to the court.
Why don't you make your submission?
I'm new to his chamber.
Yes.
Today I have joined.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th September.
22 and 23 also same. Madam.
Same, you are appealing both the matters?
29 September.
22, same order. 22.
Same bolo. I'm appealing. And 23 also same.
23 also. You are appealing all the 3 matters?
Yes, yes.
23, same order.
24 টা করে দেন বাবা তারপরে
Pension matters.
24 মানে I'm for the petition. মানে very short matter মানে.
We are already 4 minutes late. Come back tomorrow to be taken.
And the same question.
225. What I have. Pension matters will all be dismissed if no one is there. Petition is not there. Mention an urgency and then no one appears. Yes, anyone appearing? Petitioners, no one. None appears for the petitioners, no accommodation is sought, dismissed for default.
But I beg to appear on behalf of the petitioner. But kindly see my lord's last order.
Respondents,
But,
you put them on notice.
yes, but my lord's last order suggests that I should give them a copy of the order so that they can come up with the progress report. There was a previous round of litigation, my lord, for Shalkia Chourasta flyover project. My land was being acquired along with the house property standing thereon. Lord, under Act 2, Lord, this was being requisitioned. Thereafter, Lord, no award is being published. This honorable court on the last occasion, Lord, in the previous round of litigation, have directed, Lord, the corporation, Lord, the authorities of the state respondent, Lord, to consider the prayer, Lord, at page 24 and 25. Lord, Mr. They appeared, Lord, at that point of time. Lord, the suggestion was that, Lord, they can, Lord, purchase, Lord, as is various wishes, Lord. But still, Lord, the subsequent to passing of this honorable court's order, Lord, page 33 and 34, your lordship kindly see, Lord, the 34 page reasoned order is not page 33 onwards. Page 34, your lordship will get not the last two paragraphs.
Give me a minute, please.
Even my lord, yesterday my advocate on record couldn't able to find my lord those two learned advocate, but their official number, my lord, the WhatsApp is being sent and that has been shown to also.
Here there is some advocate Kainat for.
They appeared, my lord, on behalf of them. My lord, they are the recorded advocate as per, my lord, the GP office, my lord, the registrar. Wasim Ahmed.
My lord, in this matter, Mr. Wasim Ahmed is appearing for the state. If my lord may kindly grant a short pass over, man. My lord, he is engaged in code now.
Please, you can do that.
My lord, I'm not his junior in this matter. My lord, he is engaged in courtroom number 14, my lord.
Once your lordship see, my lord, page 34, what is their, my lord, actual, my lord, conclusion? My lord, last two paragraph of page 34. It is their reasoned order. My lord, 34. My lord, has your lordship got? May I just read for your lordship? My lord, the last two paragraph. But acquisition of the disputed land could not be consummated within the lifetime of the West Bengal Requisition and Acquisition Act 1948, owing to the non-placement of the fund by the requiring body, even after emphasizing the import of the placement of fund towards the completion of the proceeding initiated by the state for public purpose. As a result, acquisition case number such and such could not be concluded by the declaring award. One of the non-compensated landlord, that is not the petitioner before your lordship, being denied by the rightful compensation, had submitted an application before the Honorable Court demanding compensation as per the prevailing market value. While disposing of the application being such and such, the Honorable Court issued direction upon the LA Collector Howrah to pass necessary orders so that the petitioner can get award as per prevailing market value. Lord, kindly turns over the page. The persons under reference 3, such and such 8 others have also submitted representation for compensation as per the present market value. But in the absence of any state rule for revalidation or revival of the lapsed acquisition case, there remains no scope. Your lordship knows now, the constitutional bench judgment has come up. This point is no more res integra. They cannot say, I cannot revive. There is no question of revival. They have either they will have to initiate a fresh proceeding, or they will have to take it as per the present market value. Both my client is agreeable, but let them come with something.
Not today. Tomorrow, if the state is not there, also I'll pass on it.
Grateful,
Extremely grateful.
Only not today. Please come back.
Grateful.
Very short if you can.
Yes, yes. Let the matter may be written its position so that tomorrow your lordship. Well, then may I take back the notice?
Because he's appealing.
I'm extremely
Grateful.
27.
I am further respondent.
Under 227, Gautam Guria is appearing on the petitioner. He has come to court, but due to his illness, he had visit to doctor. Only for not today.
My lord.
Only for not today, my lord.
My lord, should not say these things. My lord, I am for the private respondent. This is instance of my mentioning. I have given 45 days effort, 1 month, 15 days effort to give a notice to Mr. Gautam Guria. I went to his chamber in the old post office state. He refuses to take it. Thereafter, I have given notice to the petitioner through registered post. My lord, your lordship, my lord, your lordship, in this matter, your lordship dismissed earlier petition since there is.
Only for not today, only for.
Not today, every matter cannot be possible. Very shortly.
ওই যে গৌতম গুড়িয়া ইনস্ট্যান্সে টাইম নিচ্ছে
Affidavit of service.
বললাম যে কি করেছে
You are filing the affidavit of service.
my lord, I have given notice to them for no, I am private respondent. They have filed it, and mere filing this, they are not doing anything. Now I have mentioned, and by giving a notice to the petitioner, all the petitioners, since the advocate on record refuses to take it.
Not today.
My lord, affidavit of service.
No.
28.
To 28, I am for the petitioner, my lord. The state is supposed to file its report today. On the last occasion, it was on 2nd of August.
No report, you also asked me to take instruction.
Instruction, clarification.
Yes, instructions.
Yes, with regard to page 36, point 4.
Column four.
Rehabilitation.
Yes. Though I have not received any written instruction, but my instruction is this, my lord.
Who is appearing for the Haldia Development Authority? You're appearing.
My lord, the plot has been allotted in favor of the father of the petitioner. Since the plot has been allotted in the father of the petitioner, and as per this, my lord, clause 4 of this my lord notification, that the minor son is not entitled to get, my lord, the separate plot. My lord.
At that time, he was a minor.
Yes, my lord. That time, because my lord, state has to take care his father, my lord, and father has been allotted the plot. And it is it's clear from page 36, clause 4, an awardee identified as family should not get any land as the authority is to take care of family at the time of eviction only. And when eviction work has been done, at that point of time, the father has been allotted one plot. And minor son is in the family of his father. That is why no separate plot has been allotted in favor of the mother petitioner.
And minor. At that time, you are.
Yes. We are from the government notification.
Your father was the awardee.
My lord, I would answer that. Let my learned friend answer the query of the court. And my learned friend for the HDA wants to make some submission. Let him make submission. I will answer both those. I'll counter all those points one by one.
That's all your submission.
This is a specific instruction. On that point, you'll also ask me
What
to take
is the
instruction.
land acquisition case in terms of which the
That has gone on. Land acquisition, land has been acquired, compensation has been paid, my lord. There is a provision of allotment of separate plot in Haldia area, my lord.
because the petitioner's case in all probability is that was a separate acquisition case, not this one.
But,
My lord, kindly,
The father was given rehabilitation in a different acquisition case.
kindly come to page 34, which my learned friend is referring. Page 34, third para, which starts with the plot number 403. The plot number 403, Hemento block of Said Khudiram Nagar colony, measuring an area of 6 decimal, was allotted in favor of Basanto Kumar Mondal, son of Kunja, that is father of petitioner, against the acquisition of Moja Tetul Bedia, LA case number 9 of 7475. It is 7475. Now
The present
is 9798. And that is at page number.
that point,
it was on that point that you wanted to take instructions. Because the
Page 23.
It's saying that it's a different LA case.
sir, file my report in the form affidavit disclosing.
84 of 9798.
Yeah, page 23, my lord, kindly come to the impugned decision.
That point I have not received any instruction, my lord. This one true. Then I shall file my lord report in the form affidavit disclosing all these things, my lord.
My lord, may I read page 23?
They have recorded the same thing. But this is with reference to, this is not, they have stated 84 of 9798.
97, 98. They are saying my case is 97, 98. Acquisition of 74, different LA case number. Because my father has a different plot. I have a different plot. My elder brother has a different plot. Everybody my elder brother was
also major at that point of time, he got that separate plot of land also. Because HDA would be referring there later that my land, the allotment of land given to me has been cancelled and given to my elder brother. That is not the case. My elder brother has a separate plot of land. At that point of time, he was major, he got it. Now, my lord, why the argument that I was a minor and this notification? Because I believe this is a notification, not a law. My lord, I would be relying on Article 31A of the Constitution. If your lordship kindly, my lord,
I think let the state come back with a report.
my lord, let them come. My lord,
But this is the issue that has to be dealt with.
yes.
The petitioner says these are all separate acquisition cases.
On that point,
Yes, do you have anything to add?
no, my lord, we act as per the guidelines framed by the state government. And this is under challenge, my lord, and state government have to clarify.
Because you are the requiring body.
Yes, requiring body.
Yes.
But we act.
No role to play here, I think.
At that time of acquisition and rehabilitation, we don't have any role.
The
But
plot will be allotted by them, my lord. They will allot the plot.
instructed by the RAC.
My lord, 2 months have been passed. They have not submitted any. Kindly short date maybe can be made.
Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear. Please serve advance copy.
Yes,
Mr. Let the matter appear at the same heading on 26th September.
Grateful, my lord. My lord, under the same heading, mention matters.
Same heading.
Grateful.
This will not be under the same heading. This will go under the heading motion.
Can it be at the
These are
top?
no longer mentioned matters. So
No. Can it be at the top few matters?
let
Top.
me see. Let's check.
Grateful, ma'am.
29.
29, my lord, I am for the petition.
You're for the petition?
I am for the petition, my lord. This is my affidavit of service
Wait, Mr.
I am for the state.
and it is my notice for upgradation. My lord, kindly treat this, at first, my lord, I be very candid before your lordship, kindly treat this application as mercy petition. I telling why. My lord, there is an
Petition as?
mercy petition. As because, my lord, initially the petition, the private respondent are approached before your lordship and seeking an order. And your lordship's order is page, my lord, the receipt,
Where is your service?
my lord.
Yes.
My lord, initially the private respondent approached before your lordship for seeking an order. Your lordship's order is page 16 where it is indicated that,
Section 10.
my lord, for consideration of the representations of the concerned respondent number 5. My lord, by virtue of this order of notice of removal was issued and page 19. Thereafter, page 19. My lord, thereafter petitioner made a representations before the concerned SDO with a direction, my lord, this is the not only illegal construction made by the petitioner himself, but the private respondent himself, the petitioner has also made a illegal construction by shutter or something in the government land. Thereafter, my lord, the under the Highway Act 10(3), my lord, an order was issued and my lord, by the subdivisional officer. And thereafter, my lord knows that, my lord, their appeal provisions is there before the DM. What the private petitioner has done, my lord, they made a representation instead of formal filing. But at this juncture, my lord, I am praying before your lordship that kindly give us a leave to file a proper appeal before the concerned authority, my lord. Till such date, my lord, no worship state. As because, my lord recorded in your lordship's order, my lord, there is, my lord, 800 people in that PWD land, and for 40 years the petitioners has been in there, my lord. Not only, my lord, several petitioners, a private respondent herein also made an illegal construction.
That doesn't authorize you to.
No, my lord, not at all. At the juncture, my lord, I have to pray before your lordship, kindly treat it as mercy petition. I know, my lord, what is there and what is not. I told my client, my client only seek a liberty that he has formally he has to approach before the DM. My lord, though that he approached to DM in April, my lord, last annexure, but DM could have communicated this is not a formal appeal against the order. You file a
The DM has no responsibility to do that.
And when the clerk, the client has come to me, my lord, I told them that you have to approach in a proper way. At first, my lord, kindly come to your lordship's order at page 16, where your lordship is kindly, my lord, recorded the contention of the petitioner herein by putting that learned counsel for the private respondent submits that the plot of question is occupied by the private respondent for more than 40 years.
I'll grant you liberty to prefer an appeal.
My lord, till such day, my lord. My lord, till such day, kindly.
March 2023, my lord, the order has been passed by the SDO.
My lord, thereafter, my lord, immediately thereafter, my lord, page.
April, my lord, they have filed.
They filed an application, but that was not in
Not
proper
appeal.
form.
My lord, I shall take all the point of interim order all before the DM, but till approaching.
Order was passed on 9 February 2023.
Last order, my lord,
10-3 order.
last page 26, my lord. 16th of order number 4.
My lord, order number 4, 16, left hand, my lord.
16th of
16 March 2020.
March.
Madam,
Liberty to prefer appeal, it will be disposed of within 1 month. Till then, no course of action.
Mile, grateful, your lords, grateful, man.
Affidavit of service. None appears for the private respondent despite service. The heard learned paragraph, heard learned counsels for the parties. Paragraph. Pursuant to an order passed by this court on 17th March 2022 in WPA 15030/2021, proceeding under section 10 of the West Bengal Highways Act 1964 was initiated against the petitioners hearing, and an order under section 10(3) of the Act was passed on 16th March 2023 by the subdivisional magistrate, Domkol, Mushidabad, directing the petitioners to remove.
My lord, that is my case, my lord. I am the private respondent. My lord, petitioners are also directed to remove all the. My lord, they are taking steps only in case of mine. Petitioner in that case where your lordship passed an order, they are also an encroacher. Page 23, it has indicated that they are also.
Directing the encroachers. Directing the encroachers to remove the encroachment on the PWD land in a stipulated time frame. Stop. The petitioners filed an application before the district magistrate Mushidabad on 5th April 2023 stating that the petitioners of the earlier writ petition were also encroachers on PWD land. Stop. Paragraph. The petitioners seek to prefer an appeal against the order passed on 16th March 2023 under section 10(4) of the Act of 1964. shall deal with the appeal on merits without dismissing the same on the ground of limitation.
Grateful.
The appellate authority is directed to consider and dispose of the appeal within 1 month from the date of filing thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma, in accordance with law. Paragraph pending disposal of the appeal, comma, no coercive step shall be taken against the petitioner by the state respondents in respect of the plot in question.
Grateful, man. Great.
Disposed of, which are 230. Yes, 230.
Madam, I am appearing. Madam,
Mr. Dev for the state?
second ground litigation.
Yes.
Madam, I'll receive my lord's order, previous order, page 116. One six one is relevant.
Yes.
But I'm reading. On the prayer of the petitioner, liberty is granted to them to implead the collector land acquisition Howrah as 7 in the because the petitioner are directed to serve the copy of the restriction along with annexure thereto. It is submitted on behalf of the parties that exchange of the affidavit is not required in this matter. The petitioner has prayed for parity with the co-owners of the property in question who have been granted enhanced compensation.
Please take the microphone. sir.
By the
Please take the microphone.
microphone. Granted enhanced compensation by the respondents in terms of the order passed in CO number 15853 W of 1995. The petitioners are recorded co-owners of the plot in question, which was requisitioned by the government for construction of godown for storage of food grains under Food Supplies Department. Possession of the plot was taken on 12th April 1945. A notification was published in the Calcutta Gazette in March 13, 1980. The land was acquired by White LA case number of 1979-80, being being admissible within a month from the date of communication of this order due to no.
I think you have missed a page. There should be another page here.
117, madam. Next page. 115. 117. Next page, madam.
No, I think there was some other page. Being admissible, it doesn't really make any sense.
Being admissible.
There should be another page in between. You have missed a page.
Madam, এটা বার করতে original. Madam, yes.
It's fine.
It is confusion.
It's not matching.
না, এটা originalটা বার করো। Original orderটা বার করো। এতে আছে এখানে। ওটাতে আছে। এটাতে আছে, এটাতে। Another.
There's another page in between.
এখানে আছে another page is here. অরিজিনালটা আছে অরিজিনালটা ওর সঙ্গে আরেকটা বার করতে এটা দেখ
Please come to page 122. That is the order. That is the page. Page 122 of your writ petition.
122
This is the second page of it.
yes being aggrieved by the amount of compensation assessed by the collector and acquisition HON'BLE, the petitioner filed a petition for enhancement of compensation, which was sent to the tribunal, which by an order dated 15th September 1989 allowed the prayer of the petitioner and granted compensation at the rate of 20% per kata, along with 30% solatium thereon and 12% per annum on the enhanced compensation. Further interest at the rate of 15% from the date of compensation till payment of the amount was also awarded by the tribunal. Pursuant to the said order, several representations were made by the petitioner which fell on deaf ears. Some of the claimants, being the co-owners of the plots in question, moved an application under Article 226 of the Constitution of India before this court of realization of their dues, and by an order dated August 3, 1992 in CO number 10559W of 1992, a coordinate bench of this court directed the authority to dispose of the claim of the co-owners within 12 weeks from the date of communication of the order. Pursuant to such order, payment was made to the said claimants co-owners by the collector and acquisition HON'BLE, who abstained from making payment of the interest at the rate of 12% per annum on the enhanced compensation. Some of the co-owners subsequently filed another writ application before this court by an order dated November 16, 1995 in CO number 15853W of 1995. A coordinate bench of this court directed disposal the matter on payment, if admissible, within a month from the date of communication of this order. Due to non-compliance of the said order, a contempt application was filed against the respondents, during pendency of which the state of West Bengal preferred an appeal against the judgment and order passed in LA case, along with an application under Section 5 of the Limitation Act, praying for condonation of delay in preferring the appeal. The application for condonation of delay was rejected by the Honorable Division Bench of this court by an order dated August 25, 2006 in scan number 3095 of 2006. Thereafter, the said co-owners were granted the enhanced compensation in terms of the direction of the court in CO number 15853 W of 1995. Learned counsel for the petitioner submits that as the interests of the petitioner are covered by the said judgment,
a view of the fact that LA case being LA case number 1 Act 8 of 1979-80, in which regard to the plot of the petitioner as well as the petitioner are also entitled to payment of enhanced compensation in compliance with the order of the court passed in SUO number 15853 W of 1995. The petitioner submitted a representation in this regard before the concerned authority on February 19, 2016, which is yet to be disposed of. The petitioner pray for a direction upon the authority to consider and dispose of the said representation of the earliest and disburse the enhanced compensation in their favor within a stipulated time. Having considered the submissions made by the learned counsels appearing on behalf of the parties, this court is of the view that as the petitioners stand on the same footing as the other owners of the property in question who were granted enhanced compensation in terms of the order passed in SUO number 15853 W of 1995, the petitioner are also entitled to some benefit. Accordingly, the writ petition is disposed of, directing the respondent number 7 to consider the dispose of the application submitted by the petitioner dated February 19, 2016 within 2 months from the date of communication of this order, after affording reasonable opportunity of hearing to all the interested parties, including the petitioner, in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week thereof. With the above observation, my lord, direct dispose of the matter. Well, thereafter, communication was made. Thereafter, my lord, after a long period, the collector submitted the report. My lord, kindly page 131. The report of the collector.
131.
131.
Yes.
131. (19/7, 2022). By violating my lord's order, after a long period, they took the hearing. Well, I am reading. Whereas it appears
Come to the relevant portion of the order.
only relevant portion. Page 132.
Yes.
From third paragraph. It is therefore clear that third paragraph.
Yes.
It is therefore clear that the compensation as well as the digital amount was paid to the landowner on account of the acquisition of their portion of the land. It appears from the LA case record that the premises in question was requisitioned in TLA 2 of 1945 or 1946 under the Defense of India Act. A new story they framed. 1939 for construction of a storage of godown for the Civil Supplies Department. Subsequently, pursuant to the proposal from the Food and Supply Department, via its memo number 5093 FS dated 3/8/1979, the stated premises were brought under the pale of the West Bengal Requisition Land Communication Continuance of Power Act number 8 of 1951. This is also a news story. In LA case number 1, Act 8 of 1979-1980, following the provisions of Section 5(2) of the Act, though the publication of notice in the Calcutta Gazette published on 13/3/1980 in the wake of the order dated 20/02/1945 made for requisition of land under the provision of 75A of the Defense Act, Defense of India rules for construction of godown for storage. This is also news story. From the papers available in the office file, it appears that LA reference case number 3 to 32 of 1989 and 40 and 41 of 1988 were heard analogously in relation to the relevant LA case for appreciation of compensation amount, while adjudicating that reference on 15/0/1989. The learned LAT Court, Howrah, considered that the notification was made under Section 4 of the West Bengal Requisition and Acquisition Act 1948, that is West Bengal Act 2 of 1948, and allowed compensation at the rate of rupees 20,000 per kata for all classes of land, along with 30% solatium thereover and 12% interest fee as per Section 23A on the enhanced compensation, and also interest at the rate of 15% from the date of possession till payment in favor of the claimant petitioner. But in the relevant LA case, the requisition of the premises in question was made under the ambit of the DI Act 1939. How it is possible, my lord, for the collector, by bypassing the order, after 45 years, they raised the new question, the DI Act. Matter was referred before the Supreme Court. My lords directed, and coordinate bench also directed to make payments. However, when I am reading, after the DI Act 1939 had died a natural death, the requisition land was brought for continuation of acquisition under the provision of Section 5(2) of the Act 8 of 1951. Section 6 of the West Bengal Requisition Land Power Act 8 of 1951 deals with provision of payment of compensation. The provision is that no respect of continued subjection of requisition land to acquisition made the act of the ordinance compensation shall be determined and paid in accordance with the provisional of section, this is what I read, Defense Act 1913, the Defense of India Act 1913. There is no provision for granting solatium and also the payment of the 12% additional compensation. How he is the above the Supreme Court. He is the above the High Court. He made a new story. However, I am reading the last DI Act. There are negotiations between the collector and the claimant, and the collector is to make an offer which is not binding unless the claimant accepts the same, and finally it is Section 19(1)(b) of the DI Act 35 of 1939 provides for appointment of an arbitrator under Section 2203 of the stated Act as judge of a High Court by the central government when no agreement is reached with the amount of compensation. The collector has no jurisdiction in case of acquisition or requisition under the DI Act and Rules 1939 to value separate interest, but to assess one single amount as compensation, and the extent acts under which the requisition and the acquisition of the premises concerned were made do not allow making any reference for non-agreement by any person interested with the amount of compensation before a LAT court, but the aforesaid LME's case were instituted before the learned LA court, Howrah. An amount of rupees 16,84,921, including solatium as decreted dues, was paid to the awardee, though compensation is to given to land loser under the pale of the DI Act 1939, sans solatium, and 12% additional compensation. Therefore, in light of the above, the claim of the petitioner for additional compensation at the rate of 12% over the enhanced amount of compensation are not legally tenable and lose for the party resident. By framing a new issue, DI Act, why not Defense of India? My lord,
Will you continue some other day?
new case. My lord, kindly, case history. 12th April 1945, the possession. Another date.
Yes,
Tomorrow.
not tomorrow, I'll give you a date. For learned counsel for the petition. Here under the same heading for further consideration. On 18th September,
18th.
yes,
231, 232, it is identical matter. See, three matters.
I'll take it all together on the same date.
Same matter, identical matter.
One at 232, same one. 32 state is not there.
230, 231, 232.
So let me just adjourn the other two matters. And let them appear on the same day. 231 and 232 take over on pair of the petitioner.
232, three matters.
Let the matter appear under the same heading on another order. 232 the same order. 234. 31 on 32.
Before rising, your lordship.
One and Mr. Deyasin, 32.
Same heading, my lord.
Before rising, your
Mention.
lordship, may I seek one indulgence? His lordship 225. I was engaged in another court and lordship, lordship can't, lordship kindly make it not today. As lordship dismiss for. Great. Great.
253.
My lord, this is that contempt, my lord. Your lordship has granted the, my lord, the time so that they can produce the stay from the appeal court. But that is the order upon the my lord, 250 kilometers of route has to be
Lordship,
produced.
in
by
this
two,
matter,
because
we
that-
had
my lord,
submitted that we have
till date,
preferred
my
an
lord, that
appeal.
has not been complied and they are asking
We
for
had
adjournment
mentioned the matter as well before the division bench. The division bench was pleased to direct the matter to appear on last Tuesday itself. But because the appeal was filed before that and it was taken, leave was taken from Honorable Justice I.P. Mukherjee, division bench, Your Lordship, the file moved because of the movement, the matter has not been listed. Otherwise, the bench had directed the matter to appear on last Tuesday. We had also prepared a compliance affidavit bringing on record the above facts. The original is in transit, Your Lordship. I have the Xerox copy, which is notarized from Patna High Court, Your Lordship. I remember Your Lordship had submitted, it had fallen from Your Lordship that until unless the appeal is heard, Your Lordship will pass necessary orders. The same was submitted before the division bench.
Stay also.
Your Lordship, the division bench had directed the matter to appear on last Tuesday itself, Your Lordship. Because of if Your Lordship could adjourn it for a month, Your Lordship. Meantime, I'll get it heard, ma'am.
Your lordship kindly appreciate. My lord's order is of, my lord, March.
Mr. Mukherjee, appeal is
No,
pending.
your lordship, no, where is the, no copy has been served upon us, no stay petition has been served upon us. No, another thing is that, my lord, Supreme Court always held that this cannot be said to be the compliance, you could not be compliant. Well, your lordship.
Your Lordship, I undertake to serve it today
Since
itself, Your
March.
Lordship. Today itself, in course of this day, Your Lordship.
Prayer of the Paragraph Learned Counsel for the alleged contemner submits that the order under contempt has been carried in appeal, which is an honorable decision bench of this court. Learned Counsel undertakes to serve a copy of the memorandum of appeal as well as the stay application filed therein to Learned Counsel for the applicant petitioner in course of this day. Paragraph, let the matter appear under the same heading on 6th October.
Obliged, Your Lordship.
Maladi, I think Maladi section 5 also there. So Maladi, all the applications, because I think Maladi, this has been time barred. So let them also.
Your Lordship, with all the applications,
Pilot,
I'll
yeah.
serve.
Applications.
All connected
Pilot.
applications.
Stay application and all connected applications there.
Your Lordship, same. Both are connected matters. Your Lordship, he was only appearing. Both petitioners, he is for the petitioner, Your Lordship. Both are connected. Your Lordship, he must have left.
Let the same order be passed.
Your Lordship. Sincerely obliged, Your Lordship.
This is my application. Now, in this matter, on 26th of July, your lordship was pleased to pass an order. Your lordship, kindly see this order.
This is the order.
So.
Calculate.
Exemption has been granted only from 10th August 2020 to 24th March.
30th September.
For the 24th March to 30th September. That is the period.
That is the.
Now, your lordship, kindly see.
That is the notification dated 10th August. That has been. Set aside by the another.
No, that has not been set aside.
Second, that has been hold.
Upheld by the another bench.
Upheld by the.
Yes. But your lordship kindly see, what about this? May I put this question to myself? What about these restrictions? These are the restrictions imposed by the state government. Movement of interstate vehicles has been stopped. From space 16, no question of challenge. No question of challenge. This is something harassing a person. Yes. Why not? No. Did they scrutinize this thing? Is it appearing in the report? They say I did not find any document. It is not required for me to find any document.
You've challenged the order dated September 14, 2022.
September 14, 2022.
Where is the order at page 70?
No matter, this is the order I have challenged. During the pendency of this matter, your lordship keep the matter pending and directed the principal secretary to decide the issue afresh. Keeping the matter pending. The principal secretary passed the same order as has been set aside by your lordship. This order, your lordship kindly see, this is the order, 14 September, page 94. Just have an order to work on.
Yes.
Page 94. Just have an order. Agin din order to work on. Tar aage order.
This was, so this has been made good. Here it says the exemption of taxes cannot be entertained.
That's right. Now, your lordship kindly see, this order, earlier order, is the same.
But this has been rectified by way of the present circular.
Now I'm coming to that. After this, your lordship was pleased to pass an order on 15th March 2023.
Yes.
Then, my lord, on 15th March 1993, 2023, your lordship kindly come to page 3 of the internal page. Second paragraph, even at the cost of repetition, this court is inclined to hold that the since petitioner is paid for exemption or adjustment of tax and additional tax for an initial period of 24th March 2020 to 30th March 2020, when the subsequent notification did not see the light of the day. The petitioner case is governed by the notification dated 10th August 2020, and the authority ought to have considered the application of the petitioner in terms of the said notification. With regard to the prayer of exemption made by the petitioner for the period 19th March 2021 to 30th October 2021, the provisions laid down section 4(3) of the West Bengal Motor Vehicles Tax Act 1979, as well as section 9(b)(5)(9) subsection 5 subsection B of the West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act 1989 come into play. Such application in terms of the provisions of the 79 and 89 Act not being made by the petitioner, the provision not made till date. The petitioner is granted liberty to file an application in terms of the provisions of law as indicated within 15 days. The order impugned 14 September 2022 is the breadth of proper reasoning and is merely the repetition of earlier order passed by this authority. The order is therefore set aside. It is submitted on behalf of the respondent that the first respondent is the competent authority to deal with the application filed by the petitioner. In view of the same, the Secretary, Transport Department, Government of West Bengal, being the first respondent herein, is directed to reconsider the application already filed by the petitioner and the subsequent application filed by the petitioner as directed by this court within 4 weeks from the date of communication of this order. Receipt of this application from the petitioner, whichever is later, upon affording reasonable opportunity of hearing to all interested persons, including the petitioner and his authorized representative in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week thereof. It is expected the matter will be revisited by the first respondent independently without being influenced by any observation made by the earlier order in the light of the observation made in the earlier writ petition by the coordinate bench as well as by in this order. Upon consideration of the matter, a report in the form of affidavit be submitted by the respondent on 10th May 2023 when the matter shall appear next. Now, your lordship, kindly see, when this report has been filed by the yes. Your lordship, kindly see, after this order has been passed, a report has been filed by Mr. Debroy's client. This is report dated 12th July 2023. It has been filed. Now, in the report, your lordship, kindly see, the reasoned order of 14th June has been incorporated at page 8. Now, your lordship, kindly see, the same repetition. It appears from the contents of the writ petition that most of the vehicles as mentioned in the writ petition are covered by the interstate permit duly countersigned by the ST of West Bengal. 2 letters number such and such, letter number such and such of the Transport Commissioner Odisha and the government Odisha are government to government communication regarding the policy decision. No copy of the letter were endorsed to the petitioner. The taxing officer PBT submitted that in the REIT application, in the REIT, the applicant has prayed for exemption of tax for non-flying of the vehicle during COVID period. Nationwide lockdown was applicable from the period 25th March 2020 to 31st May 2020. From 1st June 2020, lifting lockdown was started. Subsequently, from September 2020, all bus operators allowed with the COVID protocol. During COVID period, Government of West Bengal issued exemption of tax for transport vehicles from time to time, but the exemption was restricted only to the vehicles registered in West Bengal by notification number such and such, dated 22nd March 2021. Now the matter placed before me reconsideration of the issue regarding to the exemption of the payment of tax and pandemic period. West Bengal MB tax from the interstate buses registered in Odisha state and covered by interstate permit are collected in terms of Schedule H of the notification number such and such dated 12/9/2011, published in Kolkata Gazette 14/10/2011. As per provisions of West Bengal MB Tax Act and West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act, any exemption will only be allowed if the Transport Department, Government of West Bengal notify the same in the official gazette. The Government of West Bengal has allowed exemption of tax only in respect of the vehicles registered in terms of the Section 21 of the Motor Vehicles Tax Act 1979 by 998 dated 22/3/2021. Considering the facts and circumstances, it is found that the exemption of tax during the COVID period were restricted only to the vehicles registered in West Bengal by number such and such, dated such and such. Hence, the prayer of the writ petitioner of a waiver of the taxes owing to the pandemic period is considered and rejected. This is the 14th June. It was placed before Lordship. And after perusing this, I have also drawn your Lordship's attention, page 94 of the writ petition, indicating that your Lordship, while passing the order dated 15th March, was pleased to direct the Principal Secretary not to take any help of the observation or the order passed by the earlier authority. The same order has been passed. Your Lordship, kindly see.
Have you seen today's report, today's instruction?
Yes. What he has said.
It's granted you the exemption.
Only in respect of the big, but your Lordship, kindly see, the earlier order passed by your Lordship.
This was your only prayer in the writ petition? Grant of exemption for this period?
No, subsequent period also.
Come to prayer A?
Yes. Subsequent period also. Yes, your Lordship, kindly come to prayer A. Prayer A, page 30, 31.
The September 14, 2022 order has been set aside already.
No. September 14, by the, as communicated by the etc. Judgment 12 WPA and further directing, page 31. them to accept the tax and additional tax in respect to the period from 1st October 2020 to 31st December 2020 and from 1st January 2021 to 19th March and from 1st November till the date without any penalty. This is the period for which no vehicle can operate it in view of the restriction imposed by the state government, not anybody else. And that document I have enclosed in the writ petition. And in their findings, where not a single sentence has been written as regards to their restriction imposed by the state government for a period of 6 months and odd.
Yes, Mr. Debra. The first part has been complied with. What about the second part?
There is past notification.
That has been exempted.
That
Yes.
doesn't exist.
The second part?
Because they are not at all mentioned about the state-wise, all the big. But regarding second part, what you can see, page 71, notification dated 23rd February 2021. It is not applicable in state case because notification is 23rd February 2021, last paragraph.
No. This I am not concerned about this. This has already been set aside by the Honorable Court, 23rd February 2021. This is not the restriction. This has already been set aside. This will not applicable in this case. It has been already held. No appeal has been preferred. I am concerned about these notifications.
Only applicable for legal.
No. Yes. That has already been set aside and quashed by this Honorable Court. From page 65 itself. This is the restriction imposed by the state government. These restrictions initially start immediately after the election of 2021. And it continued till 30th November. After the Puja vacation. And this is the restriction orders. All restrictions orders, as far as I gathered, I have given. Earlier restriction order and later part also there. And it continued up to that.
They are not accepting tax from October 1, 2020.
Yes, your Lordship, can you see? They have only allowed up to 30th September 2020. Thereafter this, what about this period? May I put this question to myself? In 2021, that's their restriction they have imposed.
No, it is only the aspect of the state of West Bengal, not the other people.
No, till 30th September 2020, you have exempted.
Yes.
What about the period after 30th September, from 1st October?
First of all, I have already calculated. I have already calculated all this.
That should come by way of a report, Mr. Debra. The calculation.
And your Lordship,
can deposit the amount.
as per your Lordship's order, my client want to deposit, want to tender the tax as per your Lordship's.
If the Malad exemption is required, they ought to have submitted all the documents.
We have, as far as on 9th October 2020, before the taxing officer. What say no?
Oh, blue book, tax token, everything will be deposited.
No. That will be deposited. That will be deposited when this application will be taken into consideration. Your Lordship, can you see 4.3? Yes. Yes. Your Lordship, can you see? Application is to be filed before the. Prior to that, your Lordship, can you see?
Motor vehicles একটা কোথায় চলে গেল এখানে রাখা থাকে পাল্টা করে দিচ্ছি।
আমার একটা বই দাও।
Motor Vehicles Act.
এই দিন এই বইটা দিন।
Oh, no, I have a book. I should be able
Yes,
to use
on
it.
the last occasion, your lordship.
It is there. I know. They just mix the books together. ওদিকে নেই, ওদিকে নেই, কি দেখুন। Definitely. ওদিকটা দেখ। Motor Vehicles Act. ওখানে রাখা ছিল। ওখানে রাখা ছিল। Yes. 4-3.
4-3. Page 15 does event action is satisfied that certificate had been deferred under the event of the has been surrendered or that motor has not been issued. Then we are
No, or, this is or, not and. I have made the application. I have made the application. They did not take any steps for inquiry at all. Even though on the court's order, they did not. What my learned friend is saying? No, here no here no vehicle has been seized. No vehicle has been seized. No, maybe whatever it may be, here no vehicle. Where the vehicle has been seized, my client has been paid the penalty. Full penalty has been paid. Yes, that has already been deposited.
So you need to deposit the certificate of registration and the token.
Your lordship, kindly see the intersection. What the intersection says.
How would I know if it has been applied or not?
Yes. National lockdown, government of West Bengal restriction, I will apply.
Is it?
What are the reasons given? Can you please read it out? What are the reasons given by the authority for not considering?
আরে পড়ো, ডিসেন্সে পড়ো, তোমার ফাইলে কি লেখা আছে? জজ সাহেব সেটাই বলছেন।
Today's also been directed to consider provision 12. It is granted exemption 12 after examination of record, it appears that no supporting document in respect of flying or vehicle number number also in respect
Then what about their own restriction order?
How can there be any vehicle for flying, any document in respect of flying of the vehicle?
No question of alert. They has to comply with section 4(3) or section 9(b) of the Act.
What does 4(3) say? In this case, there was a restriction throughout the state and cross borders.
He has to surrender. Even today, he has not been surrendered.
He has to surrender what?
Surrender his paper, his certificate of registration.
No question. The section does not say so. Yes.
There is an or.
Or.
That is the first part, surrender.
Or.
The second part is applicable.
Yes.
Or that the motor vehicle has not been used or kept for use for any complete calendar month. So the first part.
He shall on application understand the refund. I made the application.
The first part is not applicable at all in this case. There is no question of a surrender. The only question is the vehicle was not plying for the particular period. So he has asked for exemption of the tax.
And the plying could not be possible, not for the vehicle is in fault. It is for restriction for the pandemic imposed by the government.
So in the light of the notifications of the state, the matter has to be considered. Where is that consideration made?
No, by this time, 1 month has already closed.
To ply your vehicle because you were permitted to deposit the current tax.
They did not accept the same. What can I do?
There is an order of this court.
Order of this court, they did not accept it. Time and again, my client went there to the PBT Calcutta.
Liberty was granted to pay the current tax and the additional.
My client, after the what amount I shall deposit? They have to inform me the current tax.
Tomorrow I shall hand it over.
Why it has not been handed over till date? I don't know.
I shall hand it over.
And please come back with a comprehensive report because this single page document deals with one part.
I shall file an import matter.
It deals with one part.
I shall file an import matter.
Yes, please do that. Please do that.
By this way, well, the time is gone. And
Mr. Devroy, I would request you to provide Mr. Chatterjee with the amount to be deposited so that he can deposit without prejudice and ply his vehicle. Because there is a liberty given by the court.
for depositing current tax. And your lordship can see the statute says that
Cannot accept it unless, my lord, the earlier tax is being calculated.
and they cannot accept the earlier tax because they did not put any counter signature. They cannot put any counter signature now. The scheme is I shall deposit the tax, they will counter sign. Scheme is for earlier period, they cannot put their counter signature. How they can accept the tax? May I put this question to myself? Under which provision of law? No, what? No, no, no. What? No, no, no. This text of the statute is this.
That has to be handed over to Mr. Chatterjee.
My lord, let him calculate anything. It is not a property tax. Let him calculate anything. It is not income tax. It is a motor vehicles tax. And the scheme of the statute in respect of interstate vehicle is this.
State of West Bengal, but without paying any tax.
I did not enter. I did not enter because no counter signature was there. And the vehicle has not been. And
Let's go by plan.
maybe, my lord, it has not. I shall say I will not. I have not entered. Can they prove it? I have entered. Can they prove it?
Let Mr. Devroy produce the calculations to you tomorrow. I'll fix a short date. Let him come back with the report. We'll deal with it.
My lord, I never bargain with the court regarding the order to be passed. My duty is to make submission before your lordship. What I think I have done it. Now it is for your lordship to pass the order.
I recorded that. Let me dictate.
This is something. Your lordship have directed something. They have passed something.
One part is complied, not the later part.
And my lord, Mr. Devroy, on the last occasion on 26, has categorically submitted. His client has accepted the policy for the exemption in respect of this period. And your lordship is pleased to record that period, 24th March to 30th September 2020, 30th September 2020, then April 2021 to 30th September 2021. Your lordship is pleased to record that. It is his statement. It is not my statement.
First portion we agree. But second portion.
Now, my lord,
far more notification.
now, my lord,
24 to 30th September, you have passed an order. In the earlier order, it says that also from April 21 to September.
And
you have agreed.
agreed.
You have agreed in principle to exempt payment of tax.
Yes.
Tax. It is recorded in the earlier order.
Earlier order. He has to do it, my lord.
Learned counsel for the state respondents
In order to change it.
relies upon an order passed by the Secretary, Transport Department, Government of West
Order.
Bengal.
But what about order?
The petitioner has been granted exemption of tax and additional tax. V-Day notification dated 10th August 2020 for the period 24th March 2020 to 30th September 2020. Stop. It is recorded in the earlier order passed by this court on 26th July 2023 that it was submitted on behalf of the respondents, on instructions, that the concerned authority agreed in principle to exempt payment of tax and additional tax by the petitioner for the period March 24, 2020 to September 30, 2020 and April 2021 to September 30, 2021. Stop. Second part reflected in the order within bracket April 2021 to September 30, 2021 has not been complied with. As appears from, as reflected from the order passed by the Secretary, Transport Department. Stop. Paragraph. Learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 22nd.
Friday is a very dicey day for this court.
First time.
No, for us also.
Friday 3:30 is dicey, not 2 o'clock.
No, for us also, because coming Friday, day after tomorrow, I do not know whether court will continue or court will at all function or not.
So you want some other day? Very nice.
Yes, my lord, other day.
20th?
কিশোরের জুনিয়রটাকে মেরেছে না, তার জন্য সব লবি করে আছে যে শুক্রবার নট টু অ্যাটেন্ড করবো। এই শুক্রবারই আমি জানি না ভাই, আমাকে যা রিপোর্ট করেছে আমি তাই বললাম। আরে জজ সাহেব ঠিক করছেন আমি জানি, আবার সামনে পরে 22 হ্যাঁ 22 তারিখে কি হবে, উই ডু নট নো ইট।
That we do not know what will happen tomorrow also. So,
No. Usually everything happened on Friday. Your lordship can see this.
they will come on 20th.
Your lordship can make it on 20th.
20th, that's what I'm saying.
20th is all right.
20th,
20.
Please serve an advance copy.
And the problem is this, my lord. My client has 6 other vehicles. All 6 are lying idle. He cannot operate because 2 vehicles. No. 2 vehicles have been intercepted by them. And prior to that, I have instructed him. After your lordship passed the last order, I have prayed categorically before your lordship. I will operate the vehicles. They will not enter. Then your lordship was pleased to opine. If you operate, it is your risk and peril. If they intercept, I cannot give you any protection. I have communicated to my client, and from there he stopped deploying. 2 vehicles, how it has come in West Bengal, I do not know. How it has come, because I have instructed him not to. 2 vehicles have come, they have intercepted, they have put into tax. It's no problem. He has committed offense. No, not of 10 vehicles, my client. No, my client says no such. Other. I know who. I know who are the other players. I know. I know how Mr. Debray's client is related with him. That also I know. I know everything. Mr. Debray also knows. So I have instructed, and he cannot operate the vehicle. That's the and for this matter, I have to wait for applying for other steps to be taken in respect of other vehicles.
Please consider the earlier order passed by this court. It was your undertaking and consider in terms of the order, please. Next matter.
256.
I am happy to be able to. Evidence service, but earlier I have deposited my lord direction to serve again. I have served my lord. Evidence service has been my lord affected. And the fact of this case is that petitioner is the owner of the carriage.
Please appeal for the respondents.
My lord, last occasion, Dhiraj Trivedi, Manavendra Bandyopadhyay, and my lord for the state Chundi Charan De, Unirban Sarkar. My lord, earlier occasion, Chundi Charan De is not appear, my lord.
All state respondents.
Yes, my lord.
So may I request Mr. Debrother to appear in this matter? State is not represented. Could you please serve a copy of the petition to Mr. Debrother?
Yes. ফাইন ইম্পোজ করেছে সেই সময় গাড়িটা আমার এখানে ছিল ওখান থেকে জিপিআর এটা হচ্ছে মুর্শিদাবাদের গাড়ি আর করেছে উত্তরপ্রদেশ আত্মীয় আর জিপিআর এর সিস্টেম দেখাচ্ছে আমার গাড়িটা এখানে আছে ধরেনি তো ওরা জিপিআর সিস্টেম তো কোই নাম্বার ইয়েস মাই লর্ড
What about Uttar Pradesh?
my lord kindly come to
Department Uttar Pradesh is also a party.
yes my lord
No, the West Bengal is also a party. You can appeal for West Bengal. But what about Uttar Pradesh?
Uttar Pradesh my lord Ashok Bihar Dhori service affected ওখানে পাঠিয়ে না ওখানে কিছু করে না এটা হচ্ছে মানে এখানে পোস্টটা ফাইট করেছে এট দ্যাট টাইম জিপিআর সিস্টেম আমার 19 তারিখে আমার এখানে গাড়ি রান করছে তাহলে কোন সিস্টেম ওখানে ঠিক করে one vehicle cannot fly in the two concurrent jurisdictions that's time to time
It's delivered. Now, what is the matter about?
well matter is that petitioner is the owner of the matter carriage vehicle so my lord having permit national permit my lord the vehicle was flying within the district my lord Birbhum Bardhaman and my lord Murshidabad the vehicle never meet the alleged my lord PO place of occurrence where my lord the Uttar Pradesh Transport Authority issued this imposed the fine 46,000 as a overloading my lord. My lord, it is evident from my GPR system my lord the Google report page 25th onwards my lord that at that alleged date my lord the carriage was flying within the my lord West Bengal Birbhum and Bardhaman my lord. How my lord a vehicle can fly concurrently in my lord two different state my lord.
Can challenge before the Uttar Pradesh, not here.
My lord, my vehicle was registered under government of West Bengal.
But the cause of action is arising entirely under Uttar Pradesh, isn't it? And there is no representative here.
But last year, what is it?
Where is the challan? The impugned challan?
My lord, page 23, my lord. Page 23, annexure P3.
It is as per the toll plaza records.
Yes, my lord.
So your vehicle must have crossed that area.
My lord, kindly come, my lord, page 27, running page, my lord.
Yes, 27.
Yes, my lord. The vehicle was within the, my lord,
On
West
2nd
Bengal.
June,
West-
where was the vehicle?
West Bengal. 2nd June, my lord.
Very 2nd June.
18th June, my lord.
2nd June. These are all 18 June records.
18 June records, my lord. 19 June, next page, my lord.
2nd June. These are all 18 June.
18 June, my lord. 19 June, my lord. They have imposed fine, my lord.
But the
19
record is of the 2nd June of the toll plaza. Challan may have been issued on 19 June, but the vehicle was at the toll plaza at Uttar Pradesh on 2nd June.
My lord, my humble submission before lordship, my lord. The vehicle never meet the, my lord, Uttar Pradesh.
Submission, sir. Please show me a document
Yes,
that
my
your
lord.
vehicle was in West Bengal on 2nd June.
Next that, my lord,
18 June documents.
or supplementary evidence, my lord, I filed the documents, my lord.
And don't you think it will be better for you if you approach the Uttar Pradesh authority? There will be unnecessarily delay,
Yes, ma'am.
isn't it? The documents are all of 18th and 19th June. I can grant you liberty to withdraw and approach the Uttar Pradesh authority.
Yes, ma'am.
Yes, you'll do that?
Yes.
Challan issued by the has issued it. The Transport Department, Uttar Pradesh, against the petitioner on 19th June 2023 is under challenge in the petition. Affidavit of service. None appears for the respondents despite service. Operate. Paragraph, the petitioner seeks to withdraw the writ petition and approach the concerned authority in Uttar Pradesh for redressal of his grievance. Paragraph, in view of the above, comma, the writ petition being WP such a disputes for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the transport authority in Uttar Pradesh for redressal of his grievance, comma, as prayed for. Paragraph, there shall however be no arrest to costs as is required. That will solve the issue faster. None appears for that. 7. Yes.
Appearing for the petitioner, your lordship.
Have you served?
Yes, lordship. I have the service. Lordship, this matter, the instant writ application has been directed against the wrongful inaction on the part of the Regional Transport Authority, Bankura, in considering the series of representations made by the petitioner herein.
Anyone appearing for the respondents?
My lord, we have not received any intimation regarding this, but what the extension route fees need to make the payment.
You are appearing for the respondents?
State.
Yes.
Lordship, we have already paid the route processing fee and the route application fee, which your lordship will find from annexure P3, at page 25.
You've applied for a route permit.
Lordship, the petition extension, lordship, extension
Of the permit.
route permit, lordship. The petitioner is already plying his bus from Humgod to Bankura. And we are asking for an extension till P mode, which is at a distance of 5 kilometers from the existing bus stop, last bus stoppage.
First terminus.
You filed an application before the authority?
Lordship, we have
Where is
series of representations has been filed. Firstly, on 11th of July 2022, the petitioner had made a representation before the Regional Transport Authority for the extension. And after that, series of representation has been made, as well as representation has been made through the pradhans of 3 different gram panchayats. That has also not been considered by the Regional Transport Authority. And lastly, on 23rd of April 2023, the petitioner had made a representation, but there has been no response from the end of the Regional Transport Authority, and they have been sitting idle over the matter, lordship.
My lord, no representations annexed over here,
Representation, yes, sir.
only from the pradhans.
Pradhans, no, annexure P3, which is at page 25. That is the representation of the petitioner, as well as annexure P6. And there has been another letter from the made through my learned advocate, which is at page 40.
This is a more comprehensive representation that may be considered. For page 43.
Last one, lordship, annexure P6 at page 43.
Page,
No date mentioned.
you have asked for supply of information in the last representation.
Supply of information, actually, lordship, I have asked for in order to know the fate of the consideration representations.
This is in substance and RTI application.
Lordship,
Cannot be directed to be considered.
lordship, then in annexure P3, kindly come to page 25.
Even if that is considered, you'll only get an information, not a permission, isn't it?
Lordship, no, kindly come to page 25 once.
Yes, or do you want to make a comprehensive representation before the authority? Stating all the details, or 25 needs to be considered?
Lordship.
Because this is not very happily drafted.
Okay,
Page
lordship.
25 representation.
Lordship.
So why don't you make a comprehensive representation?
Lordship.
Yes. Yes.
My lord, this RTI, what will be the effect of this RTI?
Where is the RTI?
The page number
She
43.
did not reply to the RTI here. She had to come before the court.
Yeah, my lord.
So all the earlier order merges with the order of the court, isn't it?
My lord.
The petitioner will file a comprehensive representation. Please deal with that within 1 month. Affidavit of sense. It is contended on behalf of the petitioner that the petitioner is an operator in the route Homegard, page OOMGARH, Homegard to Bankura, and applied for extension of the said route till T mode, T MORE mode, which is at a distance of 5 kilometers from Vikrampur bus terminus. Stop. Several representations made by the petitioner before the authority.
My lord, only one representation we found. Only one representation we found.
Are on record. Have not been considered. Stop. The petitioner seeks to submit a comprehensive representation ventilating his grievance before the concerned authority and seeks and prays for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the respondents that the secretary should deal with it. The fourth respondent be directed to deal with the representation in accordance with law. Paragraph in view of the above, the petitioner is disposed of with liberty to the petitioner to submit a comprehensive representation before the fourth respondent within 2 weeks. Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 4 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Gratefully, Your Lord.
2 weeks and 4 weeks.
Gratefully.
Eight.
Only for a day, I simple note. Mr. Sen, just let's keep for another matter division. Only for nothing else.
I'll give you a short date. Next week.
Next week.
Prayer of the petitioner, the matter is petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on
Next week, any?
15th.
Yes.
15th September.
15.
Nine.
Well, I am for the petitioner, madam.
Respondents. Another petition is pending on a
I am for the
similar
petition,
issue.
madam. In that petition, my I mentioned issue is not this similar, but on the basis of which my learned friend asking the permit, the decision is under challenge in my petition.
So both need to be taken up together.
Madam, that is
Otherwise
there.
will be conflict of decisions.
Madam, I mentioned and your lordship, yes, both the matters are.
3827 is the other matter.
My lord.
On the first matter, 19237, the state wanted to file a report.
Both the matters, is my only one submission. They filed the writ petition, kept the matter pending without getting the matter listed. Immediately after the offer letter issued in my favor, and after I moved with this honorable court, they rose up and came to this court that my matter is pending. You will also kindly see the number. They allowed the grant, they allowed the offer letter to be issued. Then they come back to the court. But this is
only extension of the period of the offer.
No.
my offer letter,
To be considered.
operator, my lord, operator extended, my lord, permit fees received, grant is waiting because the pendency of their application, petition, grant could not be made. That is the only reason. But I have a BS6 vehicle, my lord, very ready, and the petitioner, I have a very great,
The same resolution has been challenged in the other petition.
maybe, my
My
lord.
lord. Now will lordship kindly come
My
to
lord,
my
your
writ petition.
my lord, kindly
My lord,
see.
my lord, kindly come to my writ petition. It is filed, my lord, sometime way back in February.
Yes. But you did not mention.
That
No,
is
this was
exactly-
appearing. This was continuously appearing.
That's what Mr. Shamanta wants to say.
I don't know. This was
That-
continuously appearing.
You remain silent. till-
No. Time has been taken by the, no, my lord.
And
At least,
my
my
lord,
lord, at least your lordship,
about the genuineness of the
kindly
petition.
recollect, my lord, always I try to mention the matter to be listed much earlier. But here your lordship kindly
My lord,
come to
yes.
this. My challenge is the resolution adopted
Maybe,
on
my lord,
behalf
first
of the
all, who is
respondent.
he? My lord, who is he?
Yes, you have,
First of all, your lordship kindly decide.
My lord,
Who is the petitioner?
no, my lord,
What is his name?
let,
What is his residence?
He is the petitioner in the next matter.
My lord, I have brought the,
First matter, a report was sought to be submitted by the state. Are you ready with the report, Mr. Devra? No?
Specific instruction, my lord.
আমরা কোথায়
Instruction
আমরা
is
কথা
there.
বলবো?
You have applied for
ওইদিকে দেখ
offer letter was granted. In favor, out of 4 applicants, Mr. Samantor application was granted. That is.
The other applicant has filed the other petition.
Other. So we
So
are.
that resolution is under challenge.
no, grant may be made up to,
Resolution dated 22nd December 2020.
yes
yes.
Do you want to file it? Because on the earlier date, you had said that you want to file a report. And that was
December
recorded.
8, 2022. That is the resolution. My lord, grant may be made, subject to the result of this
no
petition.
no what is grant may be made my lord your lordship kindly come to I am
First
who
of all,
am I am also one of the applicant therein.
No, your application is liable to dismiss. Rejected.
You have to challenge the offer letter.
No I have challenged the very
Well,
initiations
kindly
of
see the
this offer letter.
The
The
resolution-
procedure has been challenged.
My lord, kindly see the name
I
of
am
the
not
petitioner.
not challenging the decision making process.
First of all, the
But
petition-
here I have challenged decision making process.
Maybe, but who are you? What is your name? What is your father's name? My lord, kindly see. I brought those papers.
Who are the 4 persons who were considered?
My lord, your lordship will find in my writ petition, page 28.
That-
Page 28 of my writ petition.
Some provision.
Oh, he is the client of Mr. Shamu.
My lord.
Now, your lordship kindly come to page 28 of my writ petition.
What
The
are names
resolution?
of the other 3 persons?
Yes, my lord, your lordship kindly come to page 28 of.
Page 27.
Page
of the-
26, my
Please
lord.
start page
Page
20.
26.
Now, your lordship kindly come to page 28 of my writ petition. The names, your lordship kind.
Oh, the names are here,
Lordship
yes.
picture will be clear.
You are Shamsher Alam.
Lordship,
Mine.
kindly see my instruction.
Mine.
mark. Enter picture.
বাবার নাম দিয়ে কি হচ্ছে ব্যাপারটা তো বুঝতে
Just
পারছি না।
for
তো লড়াই তো হবে অ্যাফিডেভিট পোর্শনটা কোথায় তো অ্যাফিডেভিট গ্রামাত কোথায় সন অফ জমিরুদ্দিন আনসারি
করেছি আমি the father of the student.
আনসারি কি
শামসের আলীর বাবা ও একাডেমিক
আচ্ছা, আচ্ছা।
Yes, but what is the basis of the decision? On what basis was it?
And your
taken?
lordship has already decided in another matter. Mr. Jana was there, he got the interim order. Then we have added. Now your lordship set aside these decisions, this type of decisions, where the only first come, first served basis has been granted. There your lordship has turned back to the for
First
further.
of all, what is the locus standi? What is his name? Kindly see, my lord, his cause title.
The 3rd person.
My lord, kindly see the,
Yes, page 26, his name appears.
my lord, kindly see the writ petition. My lord, kindly see. Your lordship writ petition, referred.
Yes,
Kindly see.
Shamsher Alam, the same
Oh,
person.
yes, Muhammad Shamsar Alam, son of Rahmat Ansari. Kindly see.
In the resolution, the father's name is not.
My lord, I am not on that. When he has come to the court for asserting his right, I have a right to question his identity. My lord, kindly see, Muhammad Shamsar Alam,
Yes.
son of Rahmat Ansari. Kindly come to the evidence portion.
So what makes you dispute his identity?
My lord, kindly come to the evidence portion. Then your lordship kindly see.
Yes.
He says his father's name is Rahmat Ansari.
Yes.
And Rahmat Ansari affirmed the affidavit. Kindly see. Muhammad Rahmat Ansari. Who is he? Well, I brought the,
Muhammad Shamsher Alam affirmed the affidavit.
he is the petitioner.
Yes.
He happened, his father's name is Muhammad Rahmat Ansari. Affidavit says Muhammad Rahmat Ansari. But he wrote the letter, father's name, Rahmat Ansari, not Muhammad. And he is resident of Bihar. Well, I have brought the, your lordship kindly see.
The father may be a resident of Bihar.
More so, my lord, he is the father is the constituted attorney that I will say. My lord, I don't know. Can it be a
My lord, name
Can
Muhammad, Muhammad, the word Muhammad is not there.
Not very relevant. In Muslim, it's not
Then
really
father,
very relevant.
yes, my lord, my lord. Then your lordship, kindly see the age. Kindly see the age.
Yes, 33 years.
45. Yes.
45 years.
Yes.
Where do you find 45 years?
And Shamsir Alam says his age is 30 years.
Where do you find the ages?
Muhammad Ansari says his age is 45 years. And Shamsir Alam says his age is recorded 30 years from the voter identity card. Kindly see.
Can I produce all these documents about his father?
Copy now.
এটা নিয়ে কি হবে? কি?
নিতে হবে না, অফার করলে নেবে না কি আছে?
না কোন কি হবে?
নাম মোহাম্মদ শামসুল আলম, পিতা রহমত আনসারি, মোকাম নাম্বার 47, আয়ু 30 years, link proofs. Then your lordship kindly see discrepancy in the name, in the age.
Here it is 47 years, Mr. Mukherjee. In the affidavit, it is 33 years.
33. No, my lord, as I have found, my lord, 45 years.
Page 12 of the affidavit.
Yes, my lord, 45 years, I think
Yes.
so.
45, and your age is 30 years, Shamsur Alam.
In the voters list, it is
But
47.
that is the son's
I'm talking about the
age.
son, not the father.
So father is of 45 years.
Yes.
My lord, this I am telling
No,
about.
no, where is father 45 years? Here also it is son.
No, my lord, the affidavit. Your lordship is
Mohammad Shamsher Alam has sworn the affidavit.
no, my
Not
lord.
the father.
No, my lord, kindly see page 12.
Yes, page 12.
Page 12 kahan?
It is signed by Mohammad Shamsher Alam.
কোথায় মোহাম্মদ শামসুল আলম?
Please check this. এটা দিন তো একবার না।
কি ভুল বলছে?
There are
No,
discrepancies.
I just. Okay.
So cut out. अभी कट हाँ बोल हाँ
ঠিক আছে, তো 30 years. মানে
from Sartak we obtained, there is no
then I shall produce these 33 years comes to it is about 33 years means
Here it says 45.
the I think this is a voter
List. This is
list.
the voters list.
Now, this is of the which year? I don't know. One is this,
2022.
Now, I am coming to that. This, I shall produce even my identity card, which shows the date. And then maybe Aadhaar card, which both they are different. But that cannot be by this way. But this is not a
yes clean hand. You have to approach clean hand.
no.
This is a false affidavit sworn in that case.
No, my lord, these for 33. This is 33 years, I think so. And the Aadhaar card shows that 33 years.
Please come
So,
back with
your
the-
lordship kindly, let it be kept pending, my lord.
Please
For
come
the-
back with the
Yes,
documents.
my lord, I will produce the original Aadhaar card, and because this has been shown to the commissioner, both commissioners before him. So after that, this has been taken over because everything has to be shown before the both commissioner. So that has been given. I will produce this the Aadhaar card.
In February 2023.
Yes, I will produce the original Aadhaar card.
No,
Here it is
maybe.
30 and here 33.
Yes,
37 is the.
30 and 45. 30 and 45. Father says is 45.
Very good. Do you find the father's age?
Matlab father's age is 45.
Where is the father's age?
This is man.
That from
In
the-
the affidavit itself. 45.
In the affidavit, where is the father in the affidavit? It's the petitioner.
Must be in the petition itself.
Petitioner is 33. Where is the father?
Let's
there?
tell.
Where do you find father?
Muhammad Rahmat Ansari, son of Jamiluddin Ansari, he is the father of Muhammad Hamza Alam.
Which matter?
Let it.
In their matter.
In their matter, affidavit is sworn by the petitioner, not the father.
Fathers are from the affidavit.
No, the petitioner has a.
No. This is my copy, my lord. Your lordship can see.
Original is with my lord.
No, not original, not original. Mala, kindly see. What you are doing? You might have altered them. I have obtained from what Sarthak.
That is the copy which has been served
This
upon.
is a very serious allegation.
You go for inquiry in the station. How could you do it?
In the original copy, affidavit is sworn by the petitioner himself.
Right? Then, my lord. And this is the way they have been doing all these things.
It will be dismissed on this ground itself, Mr. Mukherjee. Can't help. You have not come to court with clean hands at all.
The original, your lordship, the son's signature is there.
How can you improve on this?
Now, the copy which, the original documents.
You are supposed to serve the copy of the.
Yes,
original
that side, that I am, that I am. Because it is on my part, because the original which has been with the court, the record, that is signed by the son, the petitioner itself.
Withdraw, otherwise I'll dismiss. You have not come to court with clean hands, and no liberty will be granted.
No.
Otherwise, I have to dismiss here and now.
No. The copy has been sent. Wrong copy has been sent.
Investors house.
The same number. That copy full. You have taken the recourse of the court. Why should it? এটাকে কোন ভাবে ডেভেলপ করবে এটা বাজে কেন করলি এটা জানিস কেন
Your choice.
মানে
What do you think?
withdraw code face file only thing without any remark I will be withdrawing because of the fact this is my junior's he has taken out this application now he also told that this copy which has been served and even my copies I have found right he is right I am not on that he is right even his copy that which I have in my hand
very worst record.
I do not.
Very worst record.
Has not come with clean hands. I will allow you to withdraw. I will not grant any liberty.
No.
Otherwise, I have to record.
Only thing, my lord, that's it. If your lordship don't allow me liberty, that event I will not come up.
Then let me dismiss. You go before the division bench.
No, not on that, my lord, because my lord, the whatever be, the facts cannot change. My lord, your lordship kindly only on these grounds, your lordship, whoever we come, on these grounds, these persons will get the privilege of that. But these resolutions which is already your lordship has decided in other matters that these process.
Your client has played a.
This is not on the client's mallet. But I don't know, my junior has done this mistake because this has been.
How will you tally with the voters list? How will you improve your situation?
That I can produce.
If I grant you liberty, you'll make all the necessary corrections and come back again.
No.
That will
The affidavit for
not. Your lordship kindly appreciate one thing. I will
not spend
only.
I give you two options. You have to either withdraw without liberty or I'll dismiss on holding that you have not come with clean hands.
If your lordship.
Your petitioner, I'm sorry, your client has lost his chance.
He has come before the court when your lordship kindly appreciate.
What is the holiest place?
No. He has come with the documents. Otherwise, my lord, the oath commissioner cannot take that.
I give you two options.
Well, lordship kindly appreciate one thing. This has been signed before the oath commissioner.
Submission on this. I will give you two options.
Wrong copy has been served.
No further submissions on this. Let me dismiss it. You have the division bench.
No, that I am. That's very difficult to manage.
Without even going to the merits, only on one line order that you have not come with clean hands. That's all.
Your lordship kindly appreciate one.
A very serious offense. And your client should be thankful that I'm not referring it for investigation. Yes, what do you decide?
কিছু করবি না উইথড্র করবি মানে লেট ইট বি উইথড্র
Petitioner
স্যার
seeks
হবে
to
কেন
withdraw the writ petition.
আজকে বাজে কোনো
For
কাজ করবি না
3827.
ইয়ার মিস্টেকের জন্য তোরা তোরা এত নেগলিজেন্স তোরা এত নেগলিজেন্স এটা কপি দিবি But I beg your pardon, my lord, whatever has been.
Matters, Mr. Mukherjee, where no relaxation.
My lord, I beg your pardon, my lord, I was not asking any relaxation to that, my lord. Don't take it as an amiss, my lord, that then it is very difficult to me, my lord. You have done it earlier, you did it earlier, you have been condemned by the court number of times.
Passing an order.
It's a court, it's the holiest place.
Seeks to withdraw the writ petition. Stop. In view of the above, the writ petition being WB such and such is dismissed as withdrawn without any liberty to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no order as to costs as is certified. I'm sorry, Mr. Mukherjee, I have to be harsh on this. Next matter, the earlier matter in fact.
Well, I have submitted my papers in terms of the offer letter, let them consider for grant of permit.
Yes, Mr. Devra?
Yes. Let it be called.
Your application is at page?
Well, I have paid permit fees, everything, well, I have deposited everything, madam. I have submitted papers and documents of the vehicle, well, that is waiting for consideration. Let them consider and decide the matter regarding grant of, because I have been offered with the offer letter, madam.
Offer letter page 28.
Yes.
The other writ petition referred to in the order passed on 16th August 2023 has been withdrawn by the writ petitioner therein. Paragraph, for learned counsels for the parties. Paragraph, the petitioner seeks a direction upon the second respondent.
Madam.
Second respondent to issue.
Well, second respondent part is complete. Madam, it is secondary.
Our prayer says second.
Third respondent, madam.
Third respondent. Third respondent. To issue permanent stage carriage permit in his favor in the interstate route KCBT at Chatragachi to Markacho.
Markacho, madam.
MARKACHO in terms of the offer letter issued in his favor. Where is the offer letter?
Madam, page 28, madam.
Page 20.
On 3rd January 2023.
Madam.
On 3rd January 2023. Paragraph, learned counsel for the respondent submits that the third respondent be directed to consider the prayer of the petitioner in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to is this the repetition is allowed in terms of prayer D. In terms of prayer A. Small a. Paragraph, the third respondent is directed to consider issuance of permanent stage carriage permit in favor of the petitioner in terms of the offer letter issued on 3rd January 2023, subject to the petitioner complying with all necessary, all requisite formalities, comma, in accordance with law. Stop. The necessary formalities in accordance with law within 4 weeks.
4 weeks?
4 weeks. Within 4 weeks from the date of communication of this order. Disposed of.
My lord, I'm sorry, my lord, I have raised my voice, my lord, kindly.
No difficulty in raising your voice. Do not raise your blood pressure. That is important.
One day, my lord, he raised voice so high. The honorable judge in the division bench asked Mr. Samant to kindly cool down and kindly put up the microphone.
So that's what I said. Raising your voice is not difficult. Don't raise your blood pressure. Next one.
261.
Well, this is my application. But I am for the petition in this matter. Now, my lord, here I have served the private respondent. I have affirmed the affidavit service. Later on, private respondent received the same on 2nd September. This is the postal. Now, here, my clients are the existing operators in respect of the local route in Bardhaman district. But I have checked up the number in order to shorten your lordships. I have checked up. If it is not, I could.
This becomes a ground for appeal.
No. If it is not there, I could have instructed my learned junior, no, today matter cannot be done. That much of fairness I have, Mr. Devara knows me. Number here, my clients are, two petitioners are there. They are local operators. They have raised an objection before the State Transport Authority West Bengal regarding grant of permit in violation of the notification in Asansol area. The notification says, your lordship, kindly come to the notification. The 1 minute. The notification at page 38. This is the restriction notification. Now, last paragraph. Now, therefore, in exercise of the power conferred conferred under the said section 71(3)(a) of the Motor Vehicles Act 1988, 74(3)(a) of the Motor Vehicles 1980, the governor has been pleased to direct that the regional transport, the Bardhaman and other regional transport authority, as well as the state transport of the West Bengal, that new stage carriage permit, as well as contract carriage permit for all category of passenger transport vehicle on any route or area within the municipal limit of Asansol city or Bardhaman district shall not be issued in respect of any route touching or terminating or originating in the areas within municipal limit of Asansol city or Bardhaman district, excluding interstate stage carriage and interstate contract carriage permit. That too with the approval of the state government until further order. Now, your lordship, kindly see that this is the restriction issued as far as back on 27th October 2006. The authority, the State Transport Authority West Bengal, your lordship, kindly come to page 34. Issued this permit in favor of private respondent in violation of this notification. The route is Supur to Bedia bus stand, Morban, Ausgram, Gushkora, Nobahat bus stand, Golchi, Budbud, Panagarh city center, Raniganj Mode, Asansol, Niyamatpur, extended up to Parbelia bus stand, 2.6 kilometers as per the order of the Secretary STA 2023 on 16th February 2023. Is clear in violation of that notification. Initially, my clients made objection, and the timetable also indicates that it is within it runs through Asansol city, Asansol municipal area. The timetable next page 35. Now, initially my clients made objections at page 36 and page 37. It is not in respect of the violation of the notification, but in respect of time schedule. Subsequently, after this notification, page 41. I must say, after obtained my opinion, when all these papers they came to me, I say there is a notification, you have to raise objection on the notification itself. Then they raised the objection on 15th May,
Other earlier representations are not very well drafted, yes.
not relevant. And this is the notification made there. My client has said specifically, we have objection in respect of issuance of the said permit for the following reasons. The said permit has been issued in violation of the notification issued by Government of West Bengal such and such 20th October 2006 as published. Kolkata Gazette Extraordinary on 27th October 2006. In view of the purported notification and exercise of the power, the notification has been indicated. Then other objection has also said that the permit holder is not operating as express service, making his stoppage here and there, and also not covering the route. That apart, if the notification says you are restrained from issuing, if the permit goes, then entire thing goes. Now, there are two things. I am praying your lordship may pass either of these two orders. Either Mr. Debra has to file a report in the form of affidavit as to how this permit has been granted, whether this notification has been modified, waived, or withdrawn. I do not know. That Mr. Debra can only say because he is representing the department, or your lordship may direct them to consider the same. In respect of this, I may choose the first option because that will serve the entire purpose and that will end the procedure. Otherwise, your lordship will ask them to consider. They will not again have to file a contempt. Then on the threat of contempt, they will consider. Then your lordship will ask Mr. Debra to file a report in the form of affidavit.
Please consider whether this notification
Consider the representation and along with the private respondent also appears.
I think it should be better if you come to the report.
He telling notification now presently exists. The hearing at the time.
Instead of that, he filed a report, your lordship can decide it.
The 2006 notification.
Thereafter,
So thereafter, if there is any modification to the notification or whether the notification still holds the field. That is required.
Thereafter, this notification challenge by one.
Notification, but the division may uphold this notification. It has not been modified. Very well, let him produce that. I don't know.
Come back to the relevant documents. Since it's a very old notification, we
Yes.
don't know whether any further modifications have been made.
খারাপ কথা কোথায় বললাম ভালো কথা বললাম definitely তোমার লাগবে না
The primary grievance of the petitioners is that the Secretary, Regional Transport Authority.
No, the State Transport.
The Secretary of the State Transport Authority has issued permit in favor of the private respondent in violation of the notification issued by the Government of West Bengal bearing number 4596-8S-16/2005 dated 20th October 2006. Paragraph and counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 29th September. It's again a Friday. You are scared of Friday.
27th.
Very well, 27th.
But 27th, there is a
Problem.
29th. Let us take a chance.
Very well. 29th.
Right.
But in this matter, my lord, I beg to appeal for the petition. My lord.
Service complete.
Private respondent has refused service, my lord, and I have served a copy upon Mrs. Aishwarya, my lord. She appears for the state of Jharkhand.
I am appears for.
Yes, what is the matter about?
My lord, the matter is, my lord, that the private respondents are plying the vehicle, my lord, in violation of the condition of permit, my lord. I lodged a complaint, my lord. No action has been taken.
All four have refused.
Yes, my lord.
Where is the refusal? I can find one door lock.
My lord, refusal, my lord. I served twice, my lord. First, my lord, these two, my lord, we came back, and lastly, my lord, they all of them have refused, my lord. From the track report, my lord. Track reports are there, my lord. I also made the secretary a party by name, my lord.
Was, my lord, coordinate base was delivered a judgment.
Judgment and.
Justice Bhattacharya.
Where are you seeing the refusal, sir?
My lord, kindly see the track reports, my lord. I served twice, my lord. Firstly, my lord, it came back, the door was locked, my lord. Again served, my lord. They have refused service, my lord. The track.
Written, please show me.
Okay, service complete, it is written, my lord.
Directed item delivered to addressee is one matter. 086. 086 is.
That has been already
It
decided.
has been only delivered to Srinivas. This is delivered to sender. Sender is you. whoever. So it's not served, and there are no other traffic.
Decide করতে বলেছে।
No, my lord, I gave three track reports. I have to check that, my lord. I will check it, my lord.
Service not complete.
My lord.
Service not complete.
Let me take it back, my lord, and check it, my lord.
Decided by this court, my lord. Both the RTA sit together. Both the states sit together and decided the issue regarding incorporation of the state rule. Because a draft notification, it was incorporation, but in a final notification, it was not.
Let
Clause 8A.
learned counsel come back after service.
My lord.
Since service of the private respondents is still not complete. Let the matter stand over till 29th September.
My lord.
Hearing matters.
Hearing group 7, item number 275.
Please, Your Lordship, I appear for the petition as well. My Lord, I was in the middle of the argument, my Lord. Your Lordship would recall that matter where there is an undervaluation of the consignments of maize which were going to Bangladesh. I'll refresh Your Lordship's memory. My learned senior friend is appearing, my Lord.
A copy of the affidavit in opposition was called for on the earlier meeting. It's not on record.
On three earlier occasions, my Lord. Your Lordship, on the last occasion, was pleased to hold that Your Lordship will not take into account that the affidavit in opposition that has been filed. In that case, Lordship disregards my affidavit in reply too.
Is there.
Lordship disregards my affidavit in reply. So on a point of law, Lordship kindly hears me on that point of law.
The opposition is here, my lord.
It's not on record.
Possibly it was misplaced. No, the copy আছে
আমাদের কাছে একটা পুরনো কপি আছে
একই দিন লাস্ট দিন কি প্রপোজাল দিয়েছিলাম বলো তো মনে আছে
Lordship, on the last occasion I was arguing. Lordship had heard me in part. I was placing reliance upon a judgment passed by a division bench of this court presided over by Justice Bhaskar Bhattacharya. Lordship would recall. Before that, I just slightly, my lord, refresh my lord's memory. There was a consignment. I was the consigner. I used the Indian Railways, my lord, to transport bags of maize to Bangladesh. When they get put in the train, my lord, Once they get put in the train, the entire journey is concluded. But when they are put in the train for the first time, the railway issues a railway receipt in my favor. That railway receipt says that whatever I have disclosed as the total weight of the consignment is true and correct. And the railway receipt also discloses the exact weight quantified. Once the consignment reaches the destination, the railway does not intimate anything to me. After a period of 6 months, the railway sends a notice to me saying that there has been an undercharge. The total amount of weight that you've disclosed is undervalued. You had put in more bags or the weight was more. Therefore, you're liable to pay me X amount of money. I respond to that. I say that I am not going to pay any money because you've already issued a railway receipt in my favor. So therefore, the weightment has already taken place. So in order to vent out their frustration on me, there is another consignment. They keep that consignment with them and they say, I'll sell it off. This is basically what the premise of the case is. I have challenged the entire process, saying that you could not charge me, number one. Number two, the railway discloses that there is a weighing that takes place mid-journey. So I say that that weighing, which happens mid-journey, could not have taken place without me or my representatives being present, without me being informed, because that is a violation of our.
Have the railways made good their claim from your other consignment?
Yes. So what has happened post that, my lord, was that I'll just quickly indicate the dates to your lordship. The delivery was completed on the 11th of November 2006. They say they inform me on 14th of April 2007, which is close to 6 months later. They raise a demand on me. I respond to this demand and say that I am not liable to pay anything because the weight that I've disclosed is number one, correct. Number two, this is belated. Number three, if there is a reweighing that takes place, that reweighing has to take place in my presence. You cannot unilaterally do it behind my back. Therefore, I am not liable to pay any money. So the next consignment that I use the Indian Railways to transport, they keep that as lien. And they say that if you do not pay me the X amount of money, which is the original demand, then we will sell this off. I file the writ application, I get an interim order. According to the interim order, if I furnish a bank guarantee, I can take that back. I furnish a bank guarantee. But I must also, I'll not beat around the bush, I'll be very candid, that bank guarantee has to expire today. But because we are on, the affidavits have been completed, we are on hearing, I don't think that would be of any relevance to your lordship. Can dispose of the matter as per whatever my lord thinks is legally correct. So with respect to the lien over the second consignment, that has become infructuous because that goods have been sold by me. So today we are only with respect to the demand, whether that demand by itself is legal or illegal. So I had shown one judgment to your lordship, wherein I had, lordship, kindly look at this, my lord. This is Union of India versus Messrs. Agarwal and Company, madam. So lordship found it, madam. Versus Messrs. Agarwal and Company, madam. This is the division bench judgment, madam. This is the only judgment that I'll place reliance upon. Before that, I just canvass the points that I'm trying to make. The first is that the reweighing could not have happened behind my back without giving me an opportunity of hearing. There are provisions under the Railways Act as well as the rules that I've shown, my lord, where there is a reweighing that can take place. But there are certain exceptional circumstances in which the reweighing can take place. I had shown to your lordship the clauses which form a part of the judgment. So there is no other provision of law, my lord, which is outside of the judgment that I'm seeking to place reliance upon. In a situation where the original weightment could not be carried out because the weighing machine was faulty or had malfunctioned, is a situation where a reweighing can take place. Or if the consignor himself insists on the fact that you reweigh again, that is, if I insist, then a reweighing can take place. But in either of these situations, I will have to be notified, I'll have to be informed, I must get an opportunity of hearing. It cannot happen behind my back, number one. Number two, when I was loading the goods, there is a railway receipt issued. Section 65 I place reliance upon. It is a prima facie evidence of the weight, unless it is disproved. So prior to the reweighing, it was incumbent upon the railway authorities to first dispel that the original railway receipt was faulty, or that the railway receipt cannot be relied upon. Without doing that, they cannot reweigh. And the third, my lord, is that, I'll just place the judgment. It will slightly make it more convenient for your lordship. I'll not trouble your lordship with the provisions anymore. I've already placed that on the last occasion. Lordship directly takes up page number 21 of the judgment. This is exactly on similar facts. Lordship, everything prior to this are the provisions which have been reiterated in the judgment. Lordship kindly takes up the third paragraph, which is not emboldened. It starts with after hearing, my lord. I'll place for your lordship's convenience. After hearing the learned advocate for the parties and after going through the materials on record, we find that the goods were loaded at Chirai, Gujarat, and the railway authorities issued railway receipts against loading of the consignments, admitting that the senders' declared weight were accepted with the instruction to the SM en route to weigh jointly at the destination before delivery. However, at the destination, initially no intimation was given to the writ petitioner, complaining that the wagons were overloaded, and as a result, a total number of 683 bags was unloaded. All that was informed was that there was short delivery by specifying the number of short delivered bags, but reason for short delivery was not disclosed. And consequently, the writ petitioner removed the specified short delivered goods on October 22, 1991, expecting further delivery in future. At any rate, he was bound to remove the goods. Otherwise, he would be subject to demurrage. Subsequent in October 29, 1991, demand for penal, this is relevant, my lord, because this is exactly what has happened to me. Demand for penal charge for overloading was made for the first time, alleging excess loading, and immediately thereafter, on October 30, 2007, the writ petitioners raised disputes against the allegation of overloading and demanded reweightment of the offloaded goods. In our view, Mr. Shamunto, the learned advocate appearing on behalf of the writ petitioner respondent, was quite justified in contending that once a receipt is given by accepting the sender's declaration of weight, the burden is upon the railway to show that the declaration of weight mentioned in the receipt was not correct. In the case before us, there is no endorsement in terms of the proviso to section 65 of the Railway Act that the weight or the number of package was not checked for any reason, such as weighing machine was out of order or not available. On the other hand, the declaration of the weight given by the sender was accepted as it appears from the endorsement, of course, with the instruction that the goods should be reweighed at the destination. In my case, my lord, the exact same endorsement is given, that it's accepted. And the second, that the destination station is not where I'm reweighed. I'm reweighed mid-journey. In order to take punitive charge for overloading a wagon, the concerned parties must be given intimation of the overloading, and once the goods have been booked, after due weightment, such punitive charge cannot be levied unless the goods are reweighed in the presence of the representatives of the parties concerned. As provided in para 1451 of the IRCM, these are the rules, my lord, these are on record. The railway receipt should not be granted till the goods are correctly examined and weighed, and when the senders are required to load their consignments, the railway receipt should not be given until the loading has been completed to the satisfaction of the railways. In my case, it has been given. We are quite conscious that there may be mistakes in the measurements due to various reasons, including the fault in the weighing machine, and in such a situation, if such mistake is subsequently detected, the railway authority is always at liberty to rectify the mistake by reweighing the goods in the presence of the representatives of the party who booked the consignment. Therefore, without reweightment of the consignment in the presence of the representatives of the parties concerned, there was no scope for claiming punitive charges on the alleged ground of overloading. Moreover, even in case of overloading, as provided in para 1877 of the IRCM, the excess goods are sold and the price thereof is adjusted against the freight charge, and the penalty and the balance is returned to the representatives of the sender. In this case, no further notice was given to the sender or his representatives before unloading, disclosing that through mistake, the sender's declaration was accepted and the consignment was overweight. The alleged overweight goods were unloaded without notice to the sender or its representatives, and it was disclosed for the first time at the place of destination 1 week after the short delivery goods were permitted to be removed. My case is on a higher pedestal because they informed me 6 months after the destination station is reached. Now, the question that falls for determination before us is if the writ petitioners, the representatives of the sender, in spite of specific knowledge of short delivery, decides to accept the same without any protest, whether it can, a week after the acceptance of the goods to its custody, pray for reweighment of the goods by disputing the allegation of overloading for the first time when further charge of overloading was sought to be imposed. In our view, if the railway authority specifically declares short delivery at the destination to the representative of the sender without disclosing the reason of short delivery, the acceptance of such short delivered goods cannot create estoppel against the sender or his representative in claiming the balance amount of goods or compensation for the loss in future within the period of limitation, because the shortage is admitted by the railway authority and for non-removal, he would be liable to demurrage. The position, however, would be different if at the time of declaration of shortage of the goods at the destination to the sender's representative, the railway authority also alleges overweight and discloses that unloading of the excess goods was the reason of shortage. In such a case, if in spite of such disclosure, the representative of the sender decides to take into custody any amount of the short delivered goods without protest and without praying for reweighment of the entire goods, that is the short delivered goods and the goods unloaded behind his back, disputing the allegations of overloading, he should be precluded from raising such dispute in future when the penal charge of overloading is imposed. The moment the sender's representative takes into custody any part of the short delivered goods without protest, it would be impossible to verify in future whether there was really the excess loading that permitted amount at the time of booking. Before I take your lordship any further in the judgment, this paragraph, otherwise immaterial in terms of facts, is otherwise relevant inasmuch as this paragraph says that unless a person has been put on notice, his right of raising an objection cannot arise. So if I am notified 6 months after the actual delivery has taken place, I could not have possibly reweighed and therefore arrived at the veracity of the claim of the railways. In this case, the railway authority, having failed to disclose any reason for short delivery and having permitted the writ petitioner to remove the goods without any allegation of overloading, it acted illegally in demanding the penal charges for overloading after 1 week from the date of removal. We therefore find no substance in the contention of Mr. Das, the learned counsel appearing on behalf of the railways, that the writ petitioner, having removed the short delivered goods without protest in absence of any allegation of overloading, is precluded from disputing the correctness of the allegation. We at the same time find substance in the contention of Mr. Shamunto, the learned counsel appearing on behalf of the writ petitioner, that the amount of sale proceeds received from selling the unloaded goods should be given back to the writ petitioner, as those consignments admittedly belong to the writ petitioner. We now propose to deal with the decision cited by Mr. Das. But these would not be very relevant. For Lordship's convenience, I'll read this one, just one more page. In the case of Jagjit Cotton Textile Mill, the question whether the railway authority can realize the penal charge of overloading a wagon from the consignee instead of the delinquent consignor, and whether such provisions enabling the railway to realize the same from the consignee was violative of Article 14 of the Constitution of India. The Apex Court answered the question in favor of the railways. In the case before us, the writ petitioner did not dispute the authority of the railway to realize the penalty from the consignor in the consignee in the appropriate case, but his grievance was that without giving him an opportunity of reweighment, no penalty could have been levied when the invoice indicated that the weight mentioned therein was not in excess of the upper limit. We therefore find that the said decision does not help the appellant in any way. In the case of Vishwanath Agarwal, the consignment was booked at the owner's risk without actual weightment, and ultimately overloading was detected at Andul station. The petitioners, although disputed the demand, did not apply for reweightment, as would appear from page 28 of the judgment, and at the same time did not agree to the reweightment offered by the railway, as would appear from its letter dated so and so, as it indicated in page number so and so of the judgment. In such a case, his lordship upheld the right of the railways to demand penal charges for excess amount of consignment. In the case before us, the writ petitioners were permitted to remove the short delivered goods without making any allegation of overloading, and such allegation was made 1 week thereafter. And when the writ petitioners claimed reweightment on the very next day, the penal charge was demanded. Such prayer remained unheeded, and at the same time, no opportunity was given to him for reweightment, although in the railway receipt, the weight declared by the sender has been accepted, and it was not indicated that the consignment was not weighed at the time of booking for any reason. Therefore, the said decision also does not come in the aid of the appellant. Lordship, in this case, my lord, the court was pleased to dismiss the appeal of the railways, principally on the ground that they did not get an opportunity of hearing. They did not get notice to raise an objection, which is absolutely, my lord, pat on the point applicable to my case also. The weighment, my lord friend is right. The weighment was not done in either my presence or presence of my representatives. In fact, I wasn't even invited for that. My lord, these would be my submissions. As far as the other facts are concerned, my lord, already stated. Deeply.
My lord, this case, what my learned friend has referred to, that is no relevancy here because, first of all, they got the order of taking their goods on the basis of a conditional order that they should provide this bank guarantee.
That is the other issue.
Yes, but they have behind our back, they have revoked the bank guarantee, which they cannot. Number one, that is one thing because it is a question of revenue of the railways. Number one. Number two is, my lord, your lordship kindly see the my affidavit in opposition, page 3. Sorry, page 4.
I don't have an objection. As your lordship pleases. Lordship, my only request to your lordship kindly allows it to retain its position in the list. It's on the
Only one indulgence. In midst of this hearing, my lord, the issue which is at present before your lordship, probably the judgment which is being relied upon, my learned friend, is not a good law because there is a 3 judges benches order of Bishwanath Agarwal versus Union of India, FMA 317 of 2015, where it has been held, my lord, railway has a power of reclassify section 78. They need not give notice. Under special circumstances, as per the railway notification that came later on. That judgment, 3 judges bench judgment has clarified everything.
Please tell me the citation.
FMA 317 of 2021, my lord. Justice Banerjee, Justice Sanjeev Banerjee. Yeah, to 2000, I'm telling you, lord. I don't have the exact number, my lord, but still. FMA 317 of 2015. It's Bishwanath Agarwal, Union of India versus Bishwanath Agarwal. 3 judges bench.
Come up with the judgment.
That judgment is there with the railways. It has clarified everything.
इंडिया का लिंक है
এটা নেই দেখো
কিছুটা এফএমএ নাম্বারটা লেখো
15 আমি দেখুন থ্যাংক ইউ
FMA 370
370
you could come back
2015
I'm grateful to my learned friend. It's not the
Thank you. Assistant.
It has clarified everything, my lord. We are following on the basis of that judgment. All the orders, repayment matters are guided by this judgment.
Or learned counsel for the petitioner. Let the matter appear same heading or for the consideration.
Everything.
26th September.
3 judges bench.
Yes, my lord.
26th September.
lordship will take it up at 3:30, man. 3:30 talk. Would it be your lordship's pleasure to kindly make it part heard, my lord? I'm renewing my prayer from. I'm deeply offended.
Assistant with the judgment.
I definitely will, because in that case, I'll also have to distinguish it. It'll become incumbent upon me.
There were 2 distinguishing judgments of the honorable division benches, man. One, this one, another holding that the railway have the power. Now, as these were confronting with each other, it was sent to the larger bench. And the larger bench clarified each and every aspect. Yes, holding the power of the railways that they have a power to reclassify, remeasure as per section 79. No notice is required regarding that aspect.
In fact, my lord, I believe that the last judgment which has been distinguished by Justice Bhattacharjee is the judgment that went in the before the special, because it has the same cost title.
Yes,
that has also come.
So the judgment has been distinguished here, but we'll come back. I should not make any statement without going through it first. I'll come back. I'm deeply obliged.
26.
26.
Number 26 लिखे रखो.
276.
For the writ petitioner, my lord. Mr. Shonojit Ghosh was appearing, and I have served notice upon the government pleader also, my lord. Legal metrology is also, yes, my lord, under 126. My lord, this is a matter, my lord, with regard to rearmament also. Railways, Mr. Ghosh was here few moments back. My lord, this is in pursuant to, huh? No, report is already, everything is there in the paper book. Mr. Ghosh, my lord, was here few minutes back, my lord. I saw him few minutes. Metrology is here, but the paper books are there, my lord. Paper, I have everything. Their statements are there.
Is what his presence is required.
In that case, shall I start, my lord? Because it will take some time. If in his absence, I will not going to.
Correct.
Because Lordship, kindly record the presence of metrology. He is.
I will, but then will you just inform Mr. Ghosh about the next date?
Yes, my lord, I will definitely intimate. Yes, my lord, this is a matter which is covered by the division bench judgment.
Does it have a junior or?
Probably, my lord, I think he has got engaged in some other courts, maybe. Because this is pending for quite a while, my lord. And they are.
Come back on 19th. And appears for the railways. Paragraph, let the matter appear under the same heading on 19th September. Paragraph, the petition is
His clerk is saying that he's on legs, my lord. He's saying that Mr. Ghosh, yes, no. Hello, all the three respective parties are here. Hello, this is a matter, my lord, one lease agreement.
Another matter is going on for this.
You're not ready.
No, it's ready.
Actually, this is a matter, my lord, where the writ petitioner, my lord, entered into one lease agreement with the railways. And pursuant to that lease agreement, my lord, writ petitioner commenced loading and unloading businesses. And what happened, my lord, on a particular day, my lord, petitioner loaded some consignments in the parcel van. Upon declaring in the manifest that it is very well within the tolerable limit, that is out of 23 tons, he has loaded 17 tons. Now, my lord, before the departure from Howrah to Lordship Guwahati, it was weighed here in the Howrah, and it was found that the weight is overloaded. Now, consignment was separated, my lord. It was not sent. Now, my lord, immediately it was intimated to the writ petitioner. Writ petitioner made a representation before the authority seeking rearmament on the score that in the manifest, my lord, they have disclosed the weight that is 17 ton out of 23. So it cannot come. Which is at page 61 of the writ application. It has been passed by Honorable Justice Talukdar, my lord, at the very first instance at the admission stage. So she kindly come to page 61.
Why did you refer to the paper?
Paper book. It's paper book, page 61 of the paper book, my lord. Yes. It has been passed on 26th of November 2019, my lord. My lord, may I read? Mr. Roy, learned counsel appearing for the petitioner raised a substantial doubt with regard to the correctness of the in-motion way bridge of Howrah
Mr. Roy submits that the parcel van in respect of which the petitioners have entered into a leasing contract with the railway respondents, more particularly the North Frontier Railway, was incorrectly weighed at the in-motion way bridge at Howrah Station, en route Dibrugarh. Mr. Roy invokes Section 79 of the Indian Railway Act 1989 to seek repayment of the empty parcel van, which has now returned from Dibrugarh to Howrah. Mr. Roy submits that the punitive charges leveled by the railway respondents have already been deposited with the railways, and the petitioners are entitled to contest the defective weight of the loaded wagon by the in-motion process at Howrah, considering the fact that the manual payment of manifest of the petitioners shows that the wagon parcel could be loaded up to loaded fully up to 23 metric tons, and the cargo loaded by the petitioner was to the tune of 17 metric tons. The issue raised by Mr. Roy are contested by Mr. Ghosh, learned Railway Council. Mr. Ghosh submits that there is no complaint regarding payment of the said wagon by the petitioner ex Dibrugarh on the return journey of the loaded wagon to Howrah Station. Mr. Ghosh points out that there is a discrepancy in the payment of the cargo into the wagons as claimed by the petitioners, and such discrepancy varies from 17 metric tons to 20 metric tons. Mr. Ghosh also relies upon a purported certificate of the Controller of Legal Metrology dated 27 July 2019, certifying that the in-motion weighbridge at Howrah Station goods yard is correctly functional. Kindly point this one, because it was the statement made by the railways, which has been recorded by this Honorable Court, that the in-motion weighbridge at Howrah was functioning normally. Now, thereafter, my lord, the certain directions were issued. Before commencing further on the merits of the writ petition, this court at the outset requires the following formalities to be performed by the parties. The petitioners are directed to implead the Controller Legal Metrology as party respondent. Let a copy of the writ petition be supplied to the Controller Legal Metrology, the added respondent. Petitioners are also permitted to implead the NFR as a party respondent. Let a copy of the writ petition be served upon NFR. On the next day, railway shall submit the empty tier weight of the wagon in issue being number such and such. The empty tier weight of the wagon is to be taken in presence of the representative of the Controller Legal Metrology and the petitioner, and the other issues addressed at the bar, including the point of mental interview taken by learned Railway Council, shall be considered after the above recorded formalities are completed and presented before this court on the next date. Well, this was the interim direction. Now, thereafter, my lord, when the matter again came on a returnable date, Lordship, as Lordship, certain directions were issued. They were to comply with those directions, but they could not comply within the stipulated period. So prayer was made on behalf of the railways to extend the date of compliance. Now, my lord, during the pendency of the writ application, my lord, all on a sudden, on my writ application, another application was filed by the railways. Railway filed a separate application in connection with the present writ application, seeking direction upon the legal metrology that as because the in-motion weighbridge is non-functioning, so necessary repair direction may be issued upon the legal metrology to rectify the in-motion weighbridge. My lord, that application will start from page 66 of which I have appended in the paper book. Lordship, kindly see page 66. This is railway's application, my lord. In the said application, my lord, the railway has stated at page 75. My lord, kindly see what they have stated in page 75 before this honorable court. Now she has found, my lord, page 75 of the paper book. It is railway's statement. In reference to above, we the undersigned have jointly attended Howrah Goods in motion weighbridge at 12 hours on 23rd of December 2019 to witness the tier payment of the MTVP and found that the said weighbridge is out of order since 9:53 hours of 23/12/2019 during the payment of one loaded VPH such and such, namely National Carrying Corporation, and weight shown 0 weight copy. Well, this is a statement of the railways. Railway has said in the initial stages that it was functioning properly. Now the railways own affirmation in their own application, they say that it is not functioning properly. In presence of the ACM PG Howrah, the undersigned have checked all the seals provided on console unit and junction box and found seals are properly intact condition, but the digitizer inside the console unit is showing 0 overrange. Now, however, the VP has been weighed in both directions, the said weighbridge, but no weight indication was shown in the machine. So this is one of the statements. Now, my lord, kindly come to page 76. Next page, paragraph 12. Railway is stating further that it is pertinent to mention that at Howrah Goods, there is only one electronic in-motion weighbridge, which is very important machine for the railways for safety and security of the railway and to protect revenue loss of the railway. If the said machine is not functioning for any reason for even an hour, it is not possible for railway for conducting payment of VPSLR, for which the railway is suffering huge financial loss, as well as incident of derailment may happen due to overloading. So for the safety and security of the railway passengers and the goods, and to protect the railway from revenue loss, the proper functioning of every electronic in-motion weighbridge is indispensable for functioning of the railways and running of such trains in particular. Now, my lord, it is the statement. Now, railway has admitted that it is not functioning properly. Now, the blame game has started, my lord. Kindly see page 79. Page 79, paragraph 18. Actually, that the respondent railway state that in earlier occasion, whenever the said electronic in-motion weighbridge Howrah was out of order, then and there, appropriate action was taken by all the concerned authorities of the railway as well as the legal metrology department for repairing of the said electronic in-motion weighbridge on urgent basis. It is pertinent to mention here that the act and action of the concerned authority of legal metrology department of the government of West Bengal is contradictory, for which the safety and security of the trains carrying railway passengers and goods are in danger, as well as the railway is also suffering huge revenue loss due to non-payment of VPs. Now, Lordship, the blame has shifted from railways upon the legal metrology that they are not acting in terms of the order. They are not doing their duties. Now, my lord, kindly see the prayer portion. The prayer portion which my learned friend has made before this honorable court. The applicants thereby humbly prays that your lordship may graciously please to direct upon the concerned authority of the added respondent, that is controller legal metrology, such and such, to take appropriate steps for repairing the said electronic in-motion weighbridge at Howrah station by giving permission for opening the seals provided on console unit and junction box, or to pass any other further order which is deemed necessary. So this is railway's prayer upon seeking necessary direction upon the metrology for making necessary repair. So the first submission of the railway that it is functioning properly, my lord, they themselves negate it in their own application. Now, my lord, kindly see, thereafter, my lord, in order to comply Honorable High Court's order, my lord, a joint report was filed, which is at page 89. 89 of the paper book, my lord. Because the order of the Honorable High Court was there to conduct the payment. So that order was still there and it was still in force. So you kindly see page 89, the joint report dated 23rd of December 2008. This is witnessing of tier payment in connection of the WP number such and such, my lord. This is a present writ application. In reference to above, we the undersigned have jointly attended Howrah Goods in Motion weighbridge at 12 hours on 23rd of December 2019 to witness the tier weight of the empty wagon of such and such, and found that the said weighbridge is out of order since such and such. Now, during payment of one loaded VPH of Howrah to Dibrugarh, my lord, named National Carrying Corporation, weight shown was 0 weight copy enclosed. And in presence of the ACM and all the other and the undersigneds have checked all seals provided in console unit and junction was and found the seals are properly intact condition, but digitized shown is 0 overage. This is the joint report, and lordship legal metrology is also there. I have also signed, petitioner has also signed in the joint report. Now, my lord, there is a second joint report which is appearing at page 91.
This report says further date for payment will be fixed.
Further date, because it was not repaired properly. Now kindly see the next page, page number 91 of the paper book.
Yes.
So kindly see legal what they have done. We the undersigned have jointly attended the subject mentioned weighbridge on 23rd of December 2019 at 14 hours for rectification. Service engineer of Mrs. Digital Weighing Service System has checked all the system and found console unit showing 0 overage. And according to service engineer of Mrs. Digital Weighing, permission of inspector of legal metrology is required for opening the seals provided on junction box and console unit for checking the rectification of the said weighbridge. Well, they have done something illegal without intimating the legal metrology, my lord, who has been entrusted with upkeeping and repairing of the weighing machines. Without keeping the metrology in dark, they have asked a private enterprise, my lord, to fix the issue. And this has been taken, lordship, this has been gone into by the division bench on an earlier occasion also. A strong action was taken against the railway officials for interfering with the weighing machines as because they have not taken the legal metrology into consideration and they wanted to fix it on their own. Now, legal metrology has replied back to the railways, which is at page 93. You kindly see what legal metrology has said. With reference to the above, this is to inform you the above matter lies sub judice under the Honorable High Court Kolkata, and the concurrent permission from the Honorable High Court Kolkata is required for breaking the seal and opening the console unit and junction box for rectification of the said in motion way bridge. They said until unless there is a direction from this Honorable Court, they will not going to act anything. Now, my lord, thereafter, lordship, as because the said in motion way bridge where the payment took place, my lord, was not functioning properly, railway asked me to attend the joint payment of that particular wagon at Dankuni in motion way bridge, which is appearing at page 109, my lord. 109 of the paper book. Because initial order was that to take the in motion way bridge at the Howrah. That was the order of the Honorable High Court, my lord. Now they say, as they find that the in motion way bridge Howrah is not functioning, where the allegation of overloading, lordship, I made that. Now this was the lordship, on the 10th of January 2020, I was asked to appear for the payment at Dankuni in motion way bridge, which I objected and I said that I will not, because there is an Honorable Court's direction. Honorable High Court has specifically directed that if any payment is to be done, then it has to be done on the Howrah in motion way bridge. So I will not going to attend the in motion way bridge at in motion way bridge at the Dankuni, my lord. My objection is at the next page. Thereafter, my lord, they again called me up for joint payment. Now, this time before the Howrah and in the joint report, my lord, kindly see, which I have annexed at page 115. Again, my lord, my contention that the empty tear was, my lord, is showing less, or the in motion way bridge is defective, that got lordship substantiated. Because the empty weight of the tear is 32 tons. Lordship, kindly see what has come. 30.70 ton. Now, my lord, on this issue, my lord, there is a division bench judgment of this Honorable Court that says that if even after repayment, if it is found that the tear weight is not matching with the original weight, or there is a defect in the in motion way bridge, then the punitive charges which I have deposited with them, that needs to be refunded back. Lordship, may I hand over the Honorable Single Bench's order? And it has been affirmed by the Honorable Division Bench, my lord. Lordship has seen, lordship has taken note of this judgment on earlier occasions also. May I straight away take your lordship to the Honorable Division Bench order, my lord. Exactly similar thing happened. Legal metrology also appeared. Lordship, kindly see the division bench judgment and single bench judgment, both has been affixed together, my lord.
So you are referring to the division bench judgment?
Yeah, division bench judgment, my lord. Lordship is mat number 591 of 2022. May I assist, my lord? Yes. Lordship has found. Yes. So may I read, my lord? By the consent of the parties, all the appeals which arise out of the common order of the Honorable Single Bench are taken up for conjoint consideration. Under challenge in this bunch of appeal is the final order dated 8th of April 2022, passed by Honorable Single Bench, allowing each of the petitions connected to the respective appeals which stand listed today. Under consideration before the Honorable Single Bench was the question of transportation of goods by parcel vans from the originating railway stations point, such as Rajkot and Secunderabad, by the petitions being the consignors for ultimate unloading at Shalimar stations within the jurisdiction of Southeastern Railway. The writ petitions had primarily argued before the Honorable Single Bench that each of them was levied with a punitive charge of a high amount by the Southeastern Railway on the ground that the weight of the consignment ordered by the writ petitioners, who are the respondents in each of these appeal filed by the railways, was on the date of payment of the consignment at Poddapukur in motion way bridge at Shalimar more than what was disclosed by the consignor and in excess of the permissible limits. The writ petitioners arrived before the Honorable Court with a grievance that the way bridge at Poddapukur Shalimar Yard was defective. Hence, the consignments were not correctly weighed. The consignments were individually weighed at the point of dispatch were found to be within the permissible limits. Therefore, the writ petitioners urge the Honorable Court to direct the respondent ACR, the railways, to take assistance of the competent authority on ways and measures, being the controller of legal metrology, for checking the in-motion way bridge at Poddapukur. The writ petitioners also urge the Honorable High Court to weigh the empty general coach in which each of the consignments were carried to determine whether the empty general coach was of correct weight or not, or in other words, its stair weight conformed to the railway standards. By an order dated 26th of August 2021, in each of the writ petition, the Honorable Single Bench was pleased to direct the railway authorities as follows. I am of the view the railway authority should carry on the following activities and file a report before this Honorable Court on the adjourned date. The controller legal metrology is directed to check the in-motion way bridge in Poddapukur Shalimar. The empty general coach in which the consignment was carried should be once again weighed to determine whether the said coach is of the same weight, and the report with regard to the above should be filed before this court on the adjourned date. The matter is adjourned for a period of 4 weeks from date. Upon the matter appearing subsequently before another Honorable Single Bench, it was inter alia noticed that steps as directed to be taken by the railway authorities in terms of the order dated 26 August 2021 had not been taken, and empty wagons carrying the consignments had not been weighed. Honorable Single Bench, by a further order dated 31st March 2022, directed both Controller Legal Metrology and the railway authorities to file their affidavits disclosing steps taken in terms of order dated 26 August 2021. The matter thereafter appeared for consideration next before the Honorable Single Bench on 7th April 2022. On the said date, it was noted by the Honorable Single Bench that the railway authorities, more particularly the Senior Divisional Mechanical Engineer, ACR Kharagpur, had suo motu sought for repairs of the in-motion way bridge at Poddapukur on January 24, 2022, thereby giving a go-by to specific direction of the Honorable Court as passed on 26th of August 2021 and reiterated on 31st March 2022, directing the Controller of Legal Metrology be approached to check the in-motion way bridge. The Honorable Court found that the attempt made by the railway authorities, as admitted by the Senior Divisional Mechanical Engineer Kharagpur, to repair the way bridge on 24 January 2022, suo motu, to be act as subversion of the solemn orders of the Honorable Court. By the, my lord, here also they have attempted to rectify it without intimating the legal metrology, my lord. By the order impugned dated 8th April 2022, passed in presence of the Senior Divisional Mechanical Engineer, Southeastern Railway Kharagpur, the Honorable Single Bench was pleased to note that no plausible explanation has been afforded by the concerned railway officer for non-production of empty general coach carrying consignments for payment and for repairing the in-motion way bridge at Poddapukur suo motu without first checking the Controller of Legal Metrology. The Honorable Single Bench found the action of the railway authorities and that of the Controller of Legal Metrology to be collusive. The Honorable Single Bench further found that the very fact that the in-motion way bridge was sent for repairs on January 24 lends credence to the grievance of the writ petitioners that the in-motion way bridge was defective. Accordingly, the Honorable Single Bench directed the railways to refund all punitive charges collected in respect of the consignments of each of the writ petitioners, as well as of any of the additional or incidental charges by way of wharfage. Considering the conduct of the railway officials, the Honorable Single Bench directed payment of costs by the respondents number 3, 4, 5, and 6, being the respective dealing railway officials in each of the writ petitions. Mr. Das, learned counsel appearing for the appellant railways, principally submits that under Railway Act, and especially in terms of section 78 and 79 thereto, railways have an inherent right to measure or remeasure and or weigh or reweigh any consignments. Referring to a supplementary affidavit filed on behalf of the railway authorities before the court, Learned Railway Council submits that the Controller Legal Metrology has reported that the in-motion way bridge at Poddapukur was last checked on 14th of September 2021. It is thus submitted that no automatic presumption can be raised by the petitioner to the effect that as on the dates of arrival of the consignments at Shalimar, the in-motion way bridge was found to be defective. Also referring to a report in the form of affidavit filed by the railway authorities before the Honorable Single Bench, it is pointed out that the direction passed by the Honorable Single Bench with regard to the weighment of the empty general coach was carried out and the tier weight was found to be 39 ton. Arguing for the writ petitioners and the respondent in this appeal, Mr. Ray, learned counsel, submits that the orders of the Honorable Court as issued on and from 26th August 2021 till 8th of April 2022 amply demonstrate that the railway authorities had failed to act in terms of the solemn direction passed by the Honorable Court to ensure that the control legal metrology checks the in-motion way bridge and the empty general coach is weighed. Heavily relying on the facts as recorded by the orders of the Honorable Single Bench, learned counsel for the writ petitioner submits that the dispute does not lie qua the powers of the railways to measure, weigh, or reweigh in excess of the powers under Section 78 and 79 of the Railways Act. But the dispute lies with the specific grievance raised by the writ petitioner that the in-motion way bridge at Poddapukur was defective, and such defects in the weighment stares in the face of the records, since at the point of departure of the state consignment, the weighment was found to be within the permissible limits. It is reiterated by learned counsel for the writ petition that the goods on the consignments were not of the nature which would gain in weight during transit. Excellent. To the contrary, the Honorable Single Bench had noticed that the goods comprised of hard parcels of electronic items. It is submitted that there is no effective denial by the railways of their failure to execute in the letter and spirit of the directions of the Honorable Single Bench dated such and such. It is submitted that the conduct of the railways in not producing the empty general coach for weighment and suo motu taking steps to repair in-motion way bridge at Poddapukur betrays an activity which is subservient to the directions of this Honorable Court. In view of the matter, the learned counsel for the writ petitioner submits that the Honorable Single Bench was justified in directing return of punitive and warfare charges, as well as imposing cost on the concerned railway officials. Appearing for the Controller of Legal Metrology, Mr. Sen, learned counsel, submits that Controller of Legal Metrology has always acted in terms of the solemn orders of the Honorable Court dated 26th of August 2021 and 11th of February 2022. The Controller of Legal Metrology has stated that the last correction of the in-motion way bridge at Poddapukur was carried out on 14 September 2021. In the absence of proactive steps taken by the railway authorities to act in terms of the orders of the Honorable Court, the Controller of Legal Metrology cannot be held responsible for any violation. Having heard the parties and anxiously considering the materials placed, this court finds that the orders of the Honorable Court dated 26 August 2021, 11th February 2022, 31st of March 2022, 7th of April 2022, and lastly, on 8th of April 2022, disclose detailed application of mind to the principal facts in issue, namely the correctness of the in-motion way bridge at Poddapukur to be checked on an as-in-aris basis by the Controller of Legal Metrology. Second, weighment of the empty general coach carrying the consignments. This court notices that the direction passed by the Honorable Court on the above two issues do not in any manner affect or impact or infringe the power of the railways to weigh or reweigh the consignment as provided under Section 78 and 79 of the Railways Act. This court finds that the German issue before the Honorable Court was not the power to carry out the weighment in terms of the statute, but specifically the correctness of the weighment carried out in the facts of each case connected to the issue A and B as recorded above. Having considered the order impugned dated 8th April 2022, this court is of the view that the issues flagged by the Honorable Single Bench are embedded in hard facts, and it is in the dereliction of their lawful obligations by the concerned respondents as imposed by the solemn orders of the Honorable Court arising out of such facts that has resulted in consequential orders of imposition of cost and refund of punitive charges. For the above reason, this court is unable to discover any infirmity in the order impugned of the Honorable Single Bench dated 8th of April 2022. The order impugned dated 8th of April 2022 stands accordingly sustained with the solitary modification that the order on payment of cost shall not apply against respondent number 6, my lord, who was nowhere related to this in each of the appeals, since no cause of action has been espoused by the writ petitioners against such railway officers operating in the railway jurisdiction of outside ACR. And the railways appeal was dismissed. My lord, this is my case, my lord, when the defect was unearthed, defect was exposed, the application was filed by the railways disclosing that the in-motion way bridge is defective. Now, even after thereafter, they tried to suppress all these things, tried to engage a private agency to see what has happened, to rectify it all behind the back of the legal metrology. Now, their misdeeds has been exposed, my lord. Now, Lordship, as per this Honorable Court's direction and also as per the joint report where it has been substantiated that the contention of the petition and that the in-motion way bridge was defective, number one, and tear weight was appearing less. It has to be 32 tons. It is appearing as 30 tons. And at strength of this single bench and division bench judgment, my lord, the punitive amount which has been is there with the railways should be refunded back to me because there is no fault on my part. It has been substantiated all along. by their own statements. This is my respectful submission.
Yes. My learned senior friend is asking my lord whether the other party is released or not. Yes, yes. It is my lord, within 4:30, I shall not be complete.
Mr. Devra also has to make his submission.
Any deadline?
For the petition. That the matter appeared under the same for further consideration. Second.
22nd of September.
22nd.
Grateful, man. Lordship, only one indulgence, help me, Lordship, item number 1 in the hearing, my lord. Only this much indulgence.
I have segregated the monthly list from the supplementary list. So I hopefully.
The promotion has been used. Cross.